This meeting is being held in compliance with the Open Public Meeting Act, Chapter 231, Public Law 1975. Adequate notice of this meeting has been provided in the following manner. The annual notice was forwarded to the Asbury Park Press and posted on the Municipal Bulletin Board. All notices are on file with the Planning Board Secretary. Fire exits are located on the east and west sides of the council chambers, as well as the rear of the building. I would ask anybody with a cell phone or other device to kindly put it in silent mode for the duration of this meeting. Just as a reminder, this meeting is being recorded by APTV. Please join me in the Pledge of Allegiance. Pledge allegiance
to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all.
Today is Monday, December 9th, 2019. Councilwoman Yvonne Clayton, Mayor John Moore.
Here.
Jim Henry, Michael Manzella.
Here.
Trudy Syfax, Jennifer Souter. Here. Alexis Taylor.
Here.
Rick Lambert, and Barbara Kazak.
here. Okay, the first, the agenda is remaining the same. Can I get a motion to approve the minutes of November 25th, 2019? It was a regular meeting. Any concerns by the board?
So moved.
Okay.
Second. All in favor?
Aye.
Aye.
I abstain.
Thank you.
Okay, we have two resolutions. One, yes,
We table the first resolution till the end of the meeting.
okay. So we have one resolution for the one about the Sunset Lake Master Plan. Does anyone have any questions, concerns for the board?
Were there any changes since the last one was emailed out? Okay.
No, the last one included changes made by Jennifer Souter.
Yep.
Okay, if everything's in there,
Okay.
we're good. Can I have a motion to approve?
So moved.
Second?
Second. Oh, you second.
Thank you.
That's right.
Okay.
Okay.
Michael Manzella,
Yes.
Jennifer Souter,
Yes.
Alexis Taylor,
Yes.
and Barbara Kazak.
Yes. Okay, we're going to proceed with the 1500 Ocean Avenue application. I believe that we're picking up where we left off October 28th with questions from the public. Would you like to say anything prior, or we're going to go for the gusto?
Sure. I actually have a few administrative items just to clean up before we bring up Mr. Hughes to continue the
Okay.
public questioning. So just to lay out this evening, Mr. Hughes will be the last witness of our direct testimony. At that point, we will reserve the right to bring up rebuttal witnesses, but essentially turn the meeting over to the witnesses that Mr. Lieberman has brought this evening, and I believe he has two. Okay. There are a few things I just wanted to reiterate for the record. There were some objections I made at the initial hearing, and since there's been a number of meetings in between, I wanted to make sure that they were clear on the record. And the first actually starts with a comment and a question. At the first meeting, Mr. Lieberman indicated that Save Asbury Waterfront, or SAW, would be creating itself as a not-for-profit entity, and I wanted to know from Mr. Lieberman if that had happened yet.
I don't know, but I'll find out. I'll let you know. I honestly have no idea.
Okay.
I would like that to be clear on the record, that we would object to the concept of an unincorporated entity being represented by council. It should be clear who Mr. Lieberman represents, and if SAW has not created itself as a legal entity yet, that should be known for the record. So we'd ask for next time that that be clarified.
Jack, are you okay with that?
Sure. Mr. Lieberman, you're going to send the information?
Yep.
Okay, so for the next meeting, we should have that information.
Okay.
Okay?
And along those lines, at the very first meeting, I did put on the record the objection to having multiple questions from people who are essentially represented by council. The municipal land use law in section 10 states that the testimony of all witnesses relating to an application for development shall be taken under oath by the presiding officer, and the right of cross-examination shall be permitted to all interested parties through their attorneys if represented, or directly if not represented, subject to the discretion of the presiding officer and to reasonable limitations as to time and number of witnesses. Over the course of the last several hearings, we believe that several members of SAW have had Mr. Lieberman ask the questions on cross-examination and then ask the questions themselves, and sometimes are then being allowed to ask multiple sets of questions. And I think that's led to a very long hearing process. So we want to make it clear that we are objecting to that and putting it on the record, and ask that going forward, that those individuals that are represented by Mr. Lieberman allow Mr. Lieberman to speak for them.
And Jack, is there also the ability for there to be objections if there is a duplication by the I-Star attorney?
Yeah, I made a mistake. The attorney made a mistake. In the very beginning, Mr. Lieberman pushed the issue, and I sided with him that we would allow him to have his clients ask questions on cross-examination as well as him. The statute speaks for itself. Okay, I made an error. You can't undo the error. What's been done is done. Mr. Lieberman, what's your position?
It's a question of, it's what I said the first time. It's a question of who do I represent? I represent an organization. I don't represent the individuals. Customarily, if like I do work for the Sierra Club. If I do work for the Sierra Club, members of the Sierra Club, people who happen to be members of the Sierra Club can still ask questions. So I don't think it's that cut and dry when you have a public interest organization.
Perhaps I did make a mistake. But going forward, what I think we ought to do, I anticipate an appeal in this case one way or another. Okay? My philosophy, having represented this board for 20 years and the zoning board for 25 years, is that I don't want to have cases go up on appeal that we've narrowed down the scope of the hearing to a point where somebody creates an issue. It gets to the Superior Court, gets there for 4 or 5 months, gets remanded back for 4 or 5 months more worth of hearings because we made a very conservative call. My feeling has always been that we should make calls that get these cases in, fully vetted, and resolved. I don't think it's in the interest of anyone that we prolong the case, spend extra money from the city, all the applicants, the objectors, and so on. So I would suggest that since we started it this way, having that issue where we could be right and could be wrong, I'd rather err on the side of caution, which is if in fact, now if it turns out that you're not representing a group that's legally formed, then I would assume you're representing these individuals.
I'll get you the answer to that question.
Okay. And
I
I want to
understand
know
the point
that,
that
because
you're
if it turns out that you're not incorporated and you're not a recognized legal entity, then in fact you're representing individuals. And in that case, I would say at that point we stop allowing these individuals to cross-examine witnesses since they're represented by you. But if in fact you are representing an LLC, nonprofit entity, corporation, what have you, and it turns out that outside of that scope, then based on the analogy that you said, I would suggest we continue going the way we're going at this point. I don't want to create issues on appeal that just waste a whole lot of time.
Mm-hmm.
So I would much rather prefer to make an error on the side of caution. That's my recommendation.
And Mr. Lieberman will be directed to provide that information before the next hearing, correct?
And he has agreed to do so.
Thank you.
May I ask a quick clarifying question based on your use of the word incorporated entity? So council brought up a nonprofit, so just to clarify, that means a 501c3, which is what, essentially like a tax filing, or is the proof, like if they were an LLC, does that qualify?
Yeah, there's legal documentation that has to be filed for any one of those type of entities, as you know.
Yeah.
Because it's supplies to that case.
Okay.
I acknowledge.
Yeah, I know. We know.
Thank you. That is it for the administrative part, and we'll have Mr. Hughes now continue where we left off after the last meeting.
Okay.
Let's re-swear the witness just to make sure. I know he knows he's under oath. But
Do you swear or affirm the testimony you give during these proceedings will be the truth, the whole truth, and nothing but the truth?
Yes, I do.
State your name for the record.
Keenan Hughes.
Thank you.
Okay, then we'll proceed with public question. Feel free to step up to the microphone. Yeah, remember that the questions are all based on the testimony that was provided on October 28th by Mr. Keenan.
Yes. Warner Baumgartner, Fifth Avenue. Just by way of refreshing my memory, I think we left off right at this juncture where I was in the middle of asking some questions.
Yes.
Okay.
You were.
So I need to look at my notes here to refresh where I left off. I think I was trying to get some clarity as to how the evidence that's been presented conforms with the documentation that's required in the redevelopment plan regarding design of such a building being in harmony and using elements from surrounding structures. I think that's where we left off. So the time ran out, so I was kind of asking if there's any evidence that could be presented that shows the buildings in the immediate vicinity, across the street, across Ocean Avenue in particular, and to the south.
And I think my answer was, you know, this is a little bit of a different context than an infill building in one of the residential areas of the waterfront. It is somewhat of a standalone site. Having said that, we have provided renderings, aerial photographs, et cetera, that do show the context around this particular property. And so I believe we do meet the intent of the redevelopment plan.
Okay, do you have that slide handy to put up there of the context that this building sits in particular the building to the west? The streetscape, essentially.
I'm trying to get the screen to turn on right now. Let's see.
Oh, technical glitch,
Yeah.
all right.
There it goes.
There we go.
I think this section is showing North Beach.
This one?
Sure. So that's one illustration of the proposed beach club in comparison to the North Beach condominium
And that
across
looks
the
like
street.
a height description. I'm looking for the facade, the architectural facade of the streetscape across the street to the west.
Well, you know, I think everyone's familiar with the North Beach condominium building. I mean, that's the only structure located to the west.
That may be true, but the plan and the TRC requires that such evidence be put into the hearing here to show that.
Well, so we've already been through the TRC process. We've already been to city council. I suspect if that would have been required or a pertinent area of inquiry at the TRC, we would have been asked to provide more information along those lines. We were not. And again, as I said, this is a little bit of a different context than
All right, let me narrow
another
it. Let me
infill site
narrow
within
it
the
down.
waterfront.
Let me narrow it down specifically to the redevelopment plan, which is what this is being measured against. On page 63, under frontages, under architecture, it states that harmony with the block face on both sides of the streets is desirable. Existing buildings will provide design context. That's right out of the redevelopment plan, and that's what this is being measured against. So that's why I'm asking this line of questioning. So the bottom line is you don't have any evidence to show the facade across the street to the public.
Do we have evidence to
Right,
show
yeah.
the facade across the street? I
An
mean,
exhibit.
we could get a photograph of the building across the street if that would be helpful to you.
Okay. There is a design exception. Are you aware of the design exception that says you can violate that design requirement if it's unreasonable or impractical? That's also under the same page 63.
Can you direct me to the number on page 63?
Let's have a look here. I have to pull that up. I'm going from my notes. Let's see, waterfront plan. I'm in the CAFRA section. Page 63, let's see. I believe it's the heading of frontages under architecture.
If you're asking about the standard for granting waivers from the redevelopment plan, that was already testified to by Mr. Hughes at the last hearing.
Oh, I'm sorry, repeat that?
If you're asking about the standard for granting waivers from the architectural guidelines, that was already testified to by Mr. Hughes at the last hearing. If you're talking about the general standard.
True, it was testified to as to why you're asking for a waiver. But still, I believe, in my reading of the plan, that it requires some exhibit that shows the facade across the street. If that's not available, just say no, it's not available, and I'll be moving on.
We've already submitted all the exhibits that Mr. Hughes is going to submit.
Is that a no?
It's, if it wasn't in there.
All right, I'll move on then, okay. All right, on page 59, there's a directive that designs should encourage pedestrian activity. I think that's where we left off last time. I was trying to ascertain what kind of pedestrian interaction this building has with residents walking the boardwalk or walking Ocean Avenue. Since it's not a traditional building, it's certainly not a commercial establishment, but what, in your estimation, is the pedestrian interaction with this building, if any?
So as I testified to in connection with the requested design exceptions, you're correct. This is not a typical active storefront that you might find in a commercial district. It's not a retail operation. Having said that, the design of the building on Ocean Avenue with the proposed green wall and the welcoming arched entry, and then on the boardwalk side with the indentations within the fence line and the proposed landscaping, we feel this is it's in my opinion, an attractive facade that still provides some visual interest. And despite the fact it does not have storefront architecture, it's nonetheless still a building that has some pedestrian interest.
Okay, I'm going to take that as a no. There is no pedestrian interaction with this building.
It's
You
not what
just
Mr.
cut to the
Hughes just
chase.
testified to. That is not what he stated.
Well, I don't think pedestrians interact with indentations, do they? Like, so there is no pedestrian
I think this
activity,
section is
there?
limited to questions and not comments.
Is there any pedestrian interaction with this building?
Mr. Hughes just testified as to the pedestrian interaction with this building.
With indentations? Okay, all right, I'll move on. Early on in the testimony, we were discussing view corridors. And I believe I can actually quote this, that it does not infringe at all into the view corridor. Do you recall testifying to that?
I certainly testify that there was no impact on any of the required view corridors.
Okay. What is the width on Ocean Avenue, north to south, of this particular structure that's being proposed? The length, I should say the length.
I provided that in prior testimony. I don't have that number at my fingertips at the moment.
Okay. Does the number 218 sound familiar, 218 feet?
I don't recall the specific number.
Okay. Do you know what the width north to south on the frontage of the building across the street is?
No.
Would it surprise you if that's 205?
I don't know what it is.
Okay. So how could you state then that the view corridor is not impacted or infringed upon at all if you don't know what the frontages are of either side on Ocean Avenue?
It's pretty clear. It's because the building itself does not infringe outside of the lot, number one, and more specifically the required access easements to the north and south of the developable portion of the property.
Well, that has nothing to do with the view corridor, does it?
It has everything to do with the view corridor.
Is that right? Okay. So, let me see here. Okay, I'm going to move on. All right. The plan also tries to discourage blank walls. Now, I understand you've testified at length to the green wall, to the undulating fence on the east side. I'm asking now about the north and south walls. They seem to be blank walls. How do you plan to address that issue of the plan discouraging blank walls when the north and south sides basically are blank walls?
I disagree. They're not blank walls.
Could you show us the north or south elevation, please?
We have this one within the planning exhibits, and then Mr. Handel testified as to the other facade during his testimony as the architect. And he already answered multiple questions about the treatment for each facade.
Okay, is that the south? That's the south facade, right?
Correct.
That looks like a blank wall. Okay, thank you. All right, thank you.
Who's next? Anyone?
Motion to close.
Second.
All in favor?
Aye.
Any opposed?
No redirect. Yes. Like I said, we do reserve the right to bring up rebuttal witnesses after we've heard from the witnesses presented by Mr. Lieberman this evening.
Okay, Jack, I have a question about process at this point.
Okay.
We have, there were some documents that we received from the applicant that are, I'm guessing that there's some difference. They're new, they're additional information or
Sure.
small modifications.
So the DEP had responded, as we indicated throughout the application, the stormwater here is being reviewed by the DEP, as well as a number of other items regarding the flood zones and compliance generally with the DEP's regulations. They had come back and asked some questions, and we responded by providing them the information. Some of that information are things that we've mentioned are not within the planning board's purview whatsoever, having to do with the structure of the building. But we wanted as a courtesy to make sure that you were copied on the resubmission that we made back to them.
Okay, so this is information that is not within our purview to begin with, but you wanted to give us the extra, the courtesy.
Correct.
Okay.
And to the extent there's any questions about what has, the minor changes in the stormwater report or any stormwater calculations, we do intend to call Mr. Delaney back as a rebuttal witness, but I think for efficiency's sake, it makes sense to proceed as we're going to proceed. And if you have any questions at that time, we'll call Mr. Delaney back.
Okay, okay.
Copies of those documents were submitted to Mr. Lieberman.
Correct. And they've actually been incorporated into and referenced by his witnesses this evening.
Okay. So let's move forward.
Okay.
Mr. Lieberman,
Your turn.
your turn.
It's my turn, okay.
Come on up.
Logistics, do you want me to stay up here or head back?
Well,
I was thinking camping out.
well, wherever you choose to sit.
Okay.
I just need room up here, that's all. But- Okay, very good, thank you. All right, I call, we have two witnesses tonight. First is our professional engineer, and then we have a planner. We're going to call our engineer first. And Mary, why don't you come up here so we can get you started?
Please raise your right hand. And swear or affirm the testimony you give during these proceedings will be the truth, the whole truth, and nothing but the truth.
Yes.
Please state your name for the record.
My name is Mary Paste Goldman. I'll spell the last name P as in Peter, A, I, S as in Sam, T as in Thomas, hyphen Goldman.
Thank you.
Okay, and before we go forward, two reports were submitted to the board last week, and the applicant's attorney received a copy as well. Can we mark them into?
Identification. I would testify for them and then submit them again.
Okay, that's fine. So
We put a microphone in front of
we will put a microphone, but you know what? I need clean copies, actually, myself, if we're going to do that. So let me just.
Well, there are two microphones there, so we're okay.
Yeah,
Do you have a clean copy?
Can you just tap it, just make sure that one's good, and if you could just try the other one, if you don't mind? Okay, so they're good. They just have to be close enough.
yes, thanks.
Okay.
Okay, why don't we pre-mark this for identification?
Yeah,
and then-
absolutely. Yeah, we want to give it to Michelle and have it marked, what is it, 05?
Yes, sir.
Sure. I should put a label on it for you.
So there are two reports.
Oh, 05 and 06?
Yes. 05 is the engineer's report. And 06 is the planner's report.
right, can you just let us know when you can, which document we're looking at that the board has?
Yes.
And the dates and that the documents are?
Okay, so what you're going to be hearing testimony from right now, coming up next, is from Ms. Goldman, and that's 05, and that report is dated December 4th, 2019, and it's Rippled Water Engineering LLC.
Okay.
And that's what you're going to hear next, and then you're going to hear about the other one. Okay, very good.
Okay.
Okay,
And if I could just ask for the public so that, just stay close to your microphone.
Yeah, got it.
Okay.
okay.
Go ahead.
All right, very good. Ms. Goldman, well, you're a professional engineer, is that correct?
Yes.
And by whom are you employed?
I am employed by my own company, Rippled Waters Engineering LLC.
Okay, and what business is that company in?
Professional engineering, specializing in water resource engineering, but I have a civil engineering degree.
Tell me, what would you describe your professional experience as a professional engineer briefly, please?
Sure. I've been working in the state of New Jersey for just about 20 years. Prior to starting my own firm last year, I was with Princeton Hydro, which is a firm based in Hunterdon County, for about 16 years. And then prior to that with another civil engineering firm, Shorta Palma, that was based in Manalapan, New Jersey.
And and have you been recognized by a planning board or a zoning board as a expert before?
Yes, I have served as a environmental consultant for several boards, and then also provided testimony for stormwater designs, wastewater designs, dam removals, and river restoration and wetland work throughout the state.
Have you done work for Asbury Park?
I have. Back in 2004 through 2006, I worked with Brian Grant, who was the city engineer at the time, on the ordinance and the stormwater management plans.
Nothing since then or currently?
Nothing since then.
Okay. Just found that out tonight.
Me too. Okay.
At this time, I'd request that Ms. Goldman be recognized as an expert professional engineer.
I have a question.
Sure.
You're licensed in the state of New Jersey?
Yes, been licensed since 2005.
And it's still active?
It is.
And you're not under any discipline?
No.
I've had that happen too. Okay, very good.
Any questions from?
I will have questions about the 2004 to 2006 period, but I can wait until cross-examination for those.
Okay. No. I appreciate it. Thank you very much. All right. You reviewed certain documents before you offered any opinions in this matter. Is that correct?
Yes, that's right.
In looking at 05, I see that if you look at page 1 and go through to the top of page 3, there's a list of documents that you reviewed. Does that represent the total sum of documents that you reviewed and prior to forming an opinion or opinions in this case?
Yes, it does.
Okay. And did you have an opportunity to form any opinions? What were the questions that you were asked to address when you were retained?
So Save Asbury Waterfront had asked me to look at the site for environmental constraints and impacts, as well as stormwater management impacts from the project, and any flood impacts, since that's my core area of expertise.
Okay, and you drafted this report that's dated December 4th, 2019, marked as 05?
I did.
Why don't you, and they do contain a summary of all of the opinions that you're prepared to address tonight, is that correct?
It is.
So why don't you start, at the beginning of the report and summarize your opinions and the factual or engineering basis thereof for the board?
Okay.
What page are you starting at?
I'm going to start on page 3 of the report.
Okay.
So the first section that I cover is regarding floodplain management. Given the site being located in the VE zone, I know that there was some concern, and there has been testimony by the applicant's engineer regarding, construction code discussions on the structural analysis. However, I included in my report a note about this because DEP had commented on this, and that was in that supplemental package that was provided on November 27th. And specifically, the DEP was seeking signed and sealed foundation plans regarding the structure and its ability to withstand the forces for the flood elevations, and that everything was set above that base flood elevation. And like I said, I know we've heard testimony regarding that. My only comment with regards to that is that the drawings prepared by Handel Architects did not appear to be signed and sealed. And typically calculations like this are covered by signature and seal because structural analysis requires special certifications and education. And then there's an opportunity for, if something were to go wrong, there's somebody to go back to. You know, as engineers, we have to carry errors and omissions insurance and special liability protections because of those special certifications. I personally am not a structural engineer, so I can't speak to the validity of these calculations. However, I do have concerns with something that would be submitted that doesn't have a signature and a seal.
Do you have an opinion as to whether or not a board should accept any information from a architect or an engineer that is not signed or sealed?
Yes, I don't think it's appropriate to accept something that's not been signed and sealed. I don't know if at some future phase that is planned to be provided. However, at this point, it certainly hasn't been signed and sealed.
Okay. Why don't we continue in your report, if you would, please?
Sure. So I'm going to move to stormwater management. That's what the bulk of my comments relate to. The first comment on page 4, I provide a summary here of what the applicant had indicated, including the latest updates to the stormwater analysis that they provided in November. And the first comment that I have is regarding, again, the email from NJDEP, point number 1 on page 4. He specifically, DEP asked for an analysis regarding runoff quantity control. And I know that there was a comment made back by the applicant's engineer regarding the % impervious cover on the site. So we know the more impervious cover we have on a site, generally that results in additional runoff. And the argument has been made that we have 76% impervious cover proposed on the project site, and that's less than the 90% that was permitted under the CAFRA rules. So therefore, there would be less runoff coming from the site. My biggest concern with that is we don't really know exactly what was built with the receiving stormwater system. And to make a statement that we've somehow done better than what was permitted does not mean that we can prove that we actually did better than what was permitted. The analysis standards, when the redevelopment plan was completed, have changed somewhat. Precipitation and generally in New Jersey has increased. We've ended up having to look at tons of nuisance flooding problems in areas where they never experienced flooding until the last few years. And not looking at what I consider it's actually a term that's used in engineering speak, hydrologic trespass issues is irresponsible as an engineer to not consider. And I don't feel that sufficient evidence has been provided from an engineering standpoint to justify capacity in the receiving stormwater system for the water coming from this development.
Okay, so when you talk about the stormwater system, do you mean the sewage, the stormwater pipes that were designed by Shore de Palma about 25, 30 years ago? Is that what you're talking about?
That is what I'm referring to.
And is it your understanding that under this proposal, the stormwater will incorporate the use of that system as a significant part of it?
Yes, yeah, the primary discharge beyond anything that infiltrates into the ground is designed to connect into that system in Ocean Avenue.
And what information, in your opinion, is missing that the board should be apprised of before it can determine the adequacy of the proposed system?
Typically for a system like this, if I were to approach it myself as the designer, I would be looking at where does that ultimately discharge. We have some general information that the applicant's engineer has provided, that it ultimately goes to Deal Lake, it passes through some water quality devices, but we don't know exactly what's going on in the system currently. We don't know how many connections have been made into it, whether they're illicit or permitted. And so therefore, we really don't know how much water's running through those pipes during a storm event.
Why does that matter?
It matters because if there's a lot of water already in the system at the time that the water's coming in from this development, it has the potential to back up and then come out of catch basins, the grates in the street, and flood out onto the road.
Why do you think the applicant should be charged with providing the board with this information?
again, it goes back to an engineering responsibility. When you do a development, it's your obligation to document that you have not caused off-site problems as a result of the development you're putting in. And I don't feel the justification is here to document that there's not going to be off-site flooding as a result of this system's construction.
What other opinions did you offer in this report?
So on the next page, it goes on to page 5 of my report. I talk about something called time of concentration. The time of concentration is an engineering term to establish the longest period of time it would take a drop of water hitting the drainage area of the analysis to get to the discharge point. And an assumption was made by the applicant's engineer that 10 minutes would be an acceptable time of concentration for existing conditions and proposed conditions. It is a small site. However, assuming 10 minutes is actually longer than it will take under proposed conditions for water to reach the ultimate discharge point. Everything is piped from the roof through pipes into the system and right out into the Ocean Avenue system. And when you use a 10-minute time of concentration, you are reducing the peak rate of discharge that would come from a site and not properly accounting for the full volume of water that would be leaving the site.
Well, where did the applicant, do you have an understanding of where this 10-minute figure came from that the applicant relies on?
Yes, the 10 minutes comes from the New Jersey Residential Site Improvement Standards. It's the only state statute that has a reference to time of concentration, applies to residential sites using the rational method, which is a different method actually than was used for these calculations. These were done using the TR55 method, which is a different method. But there is no standard for this type of building for times of concentration assumptions.
Well, that's what I was going to get at. So is it your testimony that there was something wrong with the engineer for the applicant using this 10-minute figure? Is that what you're saying?
That
And
is
if that is it, would
exactly.
you explain to the board exactly what was wrong about that?
Yeah, so with using that 10 minutes, like I said before, it underestimates the peak rate of runoff leaving the site and then the volume of runoff leaving the site. And because we're connecting into that storm sewer system, if we're underestimating what's coming and potentially the timing of that flood wave making it into the pipe system, you have additional potential for what I deem nuisance flooding. It's a term used for those smaller rain events, because that's what's fitting in the pipes anyway. It's not designed for, you know, a hurricane event or a 100-year recurrence interval. It's for smaller storms.
One other question about that. Is the 10-minute figure one that applies to residential construction?
From the residential site improvement standards, yes, that's
Is
where
this
that's from.
proposal one for a residential project?
No, it is not.
Is that why it was wrong for the applicant to rely on that figure?
Yes.
So, in other words, they shouldn't have used this because this isn't a residential project and it only applies to residential projects. Is that correct?
That is correct.
Okay. And the risk of using the wrong standard here is what, from a realistic standpoint? What happens if they use a wrong number in that part of the calculation?
Using that number, like I said, under predicts the runoff volume and the peak rate of discharge, and you have the risk of having off-site flooding that you did not anticipate.
And in any event, is it true that the amount of volume that the stormwater system is going to see hasn't been properly calculated? Whether the risk materializes or not, from an engineering standpoint, by using the wrong number, is it correct that the amount of stormwater that this system is going to see hasn't been properly calculated?
Yes.
Okay. Are there any, would you please continue with your conclusions and the
Sure.
basis therefore?
So I'm on number 3 on page 5 regarding the stormwater conveyance network. It was designed for a 25-year recurrence interval. That's what the applicant's engineer included. However, there's not a lot of information provided and no mapping or figures documenting what would happen to runoff leaving the site for events larger than a 25-year recurrence interval. Given the topography of the site, and I'll touch on that later on in this testimony, I do think that water is going to run off of the roof and flood down into Ocean Avenue for those larger events, but there was no information provided by the applicant in that regard. And it goes back to this same theme I've been covering thus far, which is that there's not enough documentation to address potential off-site flooding impacts from this development.
From an engineering standpoint, is it customary to design systems for anything other than a 25-year recurrence interval?
So there are different standards for different areas. A 10-year storm event is sometimes used for conveyance networks. Frankly, that may have been what was used by Shore to Palma when they did the redevelopment plan back when it was put through. There's also systems that are designed for a 100-year recurrence interval. It really varies across the state and by regulation for the area where you are.
From an engineering standpoint, do you have an opinion as to what the proper recurrence interval was, keeping in mind that 25 years was the one relied on by the applicants?
So 25 years is acceptable for the conveyance network itself, for the piping. However, again, the engineer has an obligation to identify where floodwaters are going to go for larger events so that the city, in this case, can make proper arrangements to understand where that water is going to go and really be prepared in the event that some larger event were to happen.
And by reviewing what's been submitted by the applicant, can you see any evidence that the engineer for the applicant has satisfied the obligation of showing where that stormwater is ultimately going to go under the circumstances you described?
No.
Do you have other opinions for the board that you'd like to share with them tonight?
Sure. So number 4 on that same page is regarding pipe slopes. This is, again, goes to the point about calculations and how important they are on this type of analysis. The calculations indicated pipe slopes that were 5% on the southern system and 3% for the northern system. According to the drawings, the pipe for the south is actually 1.32% and the north is 1.45%. By having steeper slopes, there's increased capacity in the pipes when you run the calculations in that way. So again, I just feel those are additional points towards this documentation of off-site and potential hydrologic trespass issues.
Just so that we can back up for a moment, you speak about pipe slopes as if everyone on the board was an engineer and understood what that meant.
Sure.
I'm an environmental lawyer who's been doing this for 30 years and I barely know what it means. Would you explain to the board what this concept of pipe slopes is?
Sure.
And why it matters that the wrong figures may have been employed?
So if you think of it like looking at a mountain or a hill, you know, you're up on a mountain that's steeper. We're down here along the coast, we have very flat ground. The steeper the pipe is, when you add water into it, the more capacity it has to take the water down. It just runs faster, it goes quicker, and so there's additional capacity there. Just the same way that water running off a mountain is faster than water going across a flat site.
Okay, and you're indicating that the data that was used in the design submissions by the applicant incorrectly described the pipe slope as 5% for the south and 3% for the north. Is that correct?
Yes.
Okay, and in fact, instead of being 5% and 3%, your paragraph 4 indicates that it's 1.32% and 1.45%. Is that correct?
That is correct.
Okay. By not using the right data, does that mean that this system has not been properly characterized by the applicant's engineer?
Yes.
By failing to properly characterize the system, what risk in real life does that mean?
Yeah, so that goes back to that same point again, that we don't know exactly what the capacity is for the receiving pipe network, and by overestimating the capacity of the pipes coming to it, you could have additional backup of water into the pipes that are newly installed by this development.
Okay. In paragraphs 5 and 6, you conclude the same way, that the receiving system hasn't been properly characterized. In problem 5, would you describe the problem that you were addressing when you reached that conclusion?
Sure. So the survey that was provided for the site shows the catch basins, those grates in Ocean Avenue, and some information about them under existing conditions. Part of what still shows on the plans now is that one of the pipe inverts, meaning the bottom of the pipe, was obscured. That could be obscured for a number of reasons. It could have sediment that accumulated in the catch basin. It could be that it was covered by some other kind of cap, but leaving things obscured like that when you're going through a stormwater analysis does not speak to actually trying to understand capacity of what's coming and going from the system. and without actually getting a proper survey that has all that information, which may frankly involve actually vacuuming out any accumulated material in the catch basin to properly characterize what's going on there, you don't have a full picture of the capacity of what's in the system.
Okay. So what should they have done that they didn't do in order to address this based on your professional opinion?
They should have cleared out the catch basin to fully document what is in it and where those pipes go.
Okay. And in paragraph 6, what problem did you attribute to the work done by the engineer, and why does it matter?
Yeah, so here again, it's really more related to that we have just the catch basin that is shown there and what pipes are coming into and out of the catch basin, but we don't have what's the next downstream structure or what's upstream of that structure coming into it. So we can't have a clear picture of the water that would be in the pipe at the time our new pipe is now connected into it.
Okay, so what should have been done by the applicant's engineer to cure that? That wasn't done.
So when I do a project like this, I would actually drive around and have a tool to lift the grates up and use a flashlight if I need to, and work with other staff, probably the city in this case so I don't get run over, to measure what's going on and actually make sure that I have full documentation of the entire storm sewer system that I'm connecting into and that I understand what's going on.
Paragraph 7 refers to reference to an off-site stormwater plan. Would you describe why you made reference to that, what its significance is, and what your conclusion was?
Yeah, so the checklist that was submitted indicated an off-site stormwater management plan was prepared. I have not personally seen that, so I'm not sure if it was actually submitted. Typically, an off-site stormwater management plan covers a lot of these issues that I have raised. You would be looking at what are the potential impacts to adjacent properties. In fact, the New Jersey Soil Erosion and Sediment Control Standards have a standard for off-site stability, and the reason that they have that standard is to address potential impacts from stormwater discharges on adjacent properties. And there's no way to know without having this off-site stormwater management plan whether any attempt was made to ensure that no impacts are happening on adjacent properties.
Thank you. Paragraph 8 makes reference to tailwaters and certain observations that you had about the work done by the engineer with regard to tailwater. Would you explain to the board what tailwater is first, and then second, the criticism that you had as to the manner in which it was handled by the applicant? What is tailwater first?
Yeah, so tailwater is kind of what I've been describing already. It has to do with how much water is already in the system when the water from our development connects into it. And when you're actually doing a design like this, even if we were looking at a traditional stormwater basin on the surface of the ground, it's a responsibility of the engineer who's doing the design to understand what amount of water would be in the receiving pipe when you're connecting into it. Because let's say water from all of the surrounding properties are all coming into that catch basin at the exact same time, and it's only a finite fixed space, there would then be zero capacity for this new water coming into that pipe. Also, with tidal water courses, although that's not the case here, but sometimes with tides, you can have such a high tide that there's no ability for this to drain out. Like if we were dealing with a hurricane, that would actually impact this. And then you would basically be running into a wall of water. So again, you kind of run into this completely full pipe that has no capacity.
But that
for
doesn't
this new
apply
water.
here.
It does. What does not apply here?
The concern about the water coming in, the tidal
The
water.
tidal water would not be a
We have
concern
enough to deal
here.
with what
Yeah.
does apply, so let's not deal
Just
with what
using
doesn't
that
apply.
for the explanation
All right,
for
all right,
tailwater.
all right, but, okay, so fine. So in terms of this tailwater issue not being characterized, first of all, is it best, do you have an opinion as to whether best engineering practices would have required that the tailwater be quantified by the applicant's engineer?
Yeah, it's a good, it's a pretty much a standard of engineering design for roadway systems to look at tailwater like this. And since we're connecting into a roadway drainage system, that we know was designed many years ago. It's not like it was something that was recently done. It would be something that I would absolutely expect to see in a calculation for this.
Okay. With regard to paragraph 9, you discuss a path that's being constructed in relation to Phase 5 improvements.
Yeah.
Would you briefly explain that and explain why that matters, please?
Yeah, so with this one, it really comes back to making sure that you're not having impacts on adjacent properties. And this is a piece where it's going to be constructed as part of the Phase 5 improvements. And the statement was that a smooth transition, maintaining positive drainage at all locations where it is expected to connect to existing infrastructure would be made. I have a hard time understanding how, if it's being built at a future phase, they can ensure that proper drainage is being made at that site.
Okay. Staying on page 6, you have a section entitled Soil and Infiltration Concerns.
Yes.
And in paragraph 1, you discuss a question concerning the depth to groundwater.
Yeah.
First of all, in designing or evaluating a stormwater system, would you explain why it's important to understand the depth to groundwater?
Absolutely. So depth to groundwater becomes really critical for an infiltration stormwater system. Understanding where the seasonal high groundwater table is, which is basically the highest the groundwater table ever gets. It typically happens in the spring of the year. It's when you have, all the snow melt has happened and everything is fully saturated. We have the highest river flows and everything is kind of at its highest level. If that is within a certain distance of the bottom of the proposed infiltration system, it impacts its ability to function as an infiltration system. In simpler terms, it can actually make it so that no water is infiltrating into the ground at all. And in some cases, if the system is designed where that seasonal high water table intercepts it, you can actually have a system where it's draining groundwater and then has no capacity for stormwater.
Okay. So when you explained why the concept of depth to groundwater is significant, you said that that is only significant in systems that rely on an infiltration basin.
Yes.
Does the system that is proposed by the applicant rely in part on the use of an infiltration system?
It does.
Okay. Is there any question that that's true?
No.
Okay. And so the concern that you have about depth to groundwater relates strictly to that part of the stormwater system that the applicants designed, which is incorporating infiltration. Isn't that correct?
That is correct.
Infiltration is when the stormwater seeps into the ground. Isn't that correct?
That's right.
And if you don't understand where the groundwater is there a risk that the stormwater won't have any place to go because it will be ineffectively blocked by the groundwater?
That's
if you
right.
don't know where it is.
Yes.
Okay. And do you have within a reasonable degree of certainty, can you conclude whether or not the applicant has provided a satisfactory answer in terms of where the groundwater is and the part of the system that will rely on infiltration?
No, they provided a series of soil borings and test pits, and they relied on the groundwater table from the borings, which was at a certain elevation that's actually referenced on page 7 of my report, which is down about 8.5 feet below the bottom of the proposed stormwater system. That's under comment 2 on page 7.
What does that mean and why is that wrong?
It's not the most conservative based on the soils information they provided. On page 6, under 1A, test pit 5 indicated significant amounts of perched water at 5 feet below the existing grade, which
Okay.
is approximately elevation 6.7, which would be much higher than that elevation that was referenced from the soil borings.
Okay, so are you saying that the borings that were employed took samples that were too deep?
Not necessarily. So with soils, it becomes a little bit unclear.
Okay.
And if I were given these types of soil results where I had test pits and soil borings that gave me different answers,
Okay.
I would need to talk to a geotechnical engineer. In this case, it was Mellick and Tully, who conducted those. Oh, sorry, not Mellick and Tully, French and Perillo, who conducted those test pits. And I would ask them, if they had an explanation for that perched water table. Maybe it was just some arbitrary singular point, but I didn't see any documentation provided by the applicant's engineer to explain that.
Perched water is what water?
So perched water can be caused by a bunch of different things, but it's typically related to a layer in the soil profile, which is if you were to cut a slice, almost like a slice of cake, you have all these different layers, and you would have this layer that is hydraulically restrictive, meaning that water can't go through it. So you have a perched condition in that situation.
Just so I understand, though, they needed to determine depth to groundwater to ensure the system works. Is that correct?
That's correct.
The way you determine depth to groundwater is by taking soil borings. Isn't that correct?
Typically for stormwater, it's done with test pits. You can use soil borings if you have a site that has a lot of constraints, but it's typically done with test pits.
Did they take test pits?
They did.
And so then, in conclusion as to this issue, what is your problem then with the test pits that they took? Would you just explain it in that way?
Sure. The test pits that were completed had enough information regarding potential perched water in test pit 5, and then there's also a note about test pits being terminated at the bottom of pool. I'm not sure what that refers to, but it's enough uncertainty in the test pit logs that were provided that additional documentation and support would really be necessary to guarantee that they have characterized seasonal high water table correctly.
Would that be in the form of additional testing? Is that what it would be, or what would it be?
It might be. It might also be in the form of putting a monitoring well in just to kind of take a look. They did run into a lot of construction debris in the test pits, so it could have been a function of debris, really sort of classifying the level of construction debris and waste at the site may also be one way to address it.
How do you know that they ran into this construction debris at the site?
That's included in all the test pit logs. They talk about running into large pieces of concrete and other debris.
Does the fact that they ran into construction debris at the site raise any red flags to you in terms of the feasibility of the stormwater system?
Well, it did initially. However, with this latest update to the design, in order to respond to some DEP comments, they have now proposed to do a soil replacement for a full 8.5 feet below the surface of infiltration. So they're going to remove any debris that would exist under the system. So from that standpoint, it does not concern me with the debris.
So the construction debris is no longer an issue
That's
as far
correct.
as you're concerned?
Mm-hmm.
Okay. If you look at page 7 under letter B at the top,
Yes.
you ask what does the bottom of pool represent?
Mm-hmm.
What are you talking about there, and why does that matter?
So they had that note in Test Pit 5 and Test Pit 7's logs. One of them was terminated at 7 feet below the ground, and one was terminated at 4 feet below the ground. I'm not sure if that's referring to some sort of buried swimming pool or a pool of water. It's just a little bit unclear. I assume because it hit refusal, which typically means that they ran into something that they could no longer dig through, that this pool is something else. But there was no information provided that I could see that talked about what that pool referred to.
What do they, and from an engineering standpoint, would you consider that to be important or material?
I would be really concerned with that, to be honest, because it would be something that would drive construction cost up potentially. I mean, I know they're coming in and doing the soil replacement, but not really knowing what that is that they're running into could add significant cost, and then ultimately could impact the functionality of the stormwater system, depending on what it is.
Why don't you review the balance of the report and tell me if you have any other conclusions or observations that you wanted to share with the board this evening?
So under number 3 on this page 7 of the report, I had provided an exhibit which is attached, and you all should have that in your packets, which has...
Why don't you identify it? What's the date and what's it entitled?
So I did this over the boundary and topographic survey map for Ocean Avenue, sheet 1 of 1. It was prepared by Bowman Consulting, dated March 29th, 2018. It was just the existing conditions survey.
And it was part of the exhibit of your report, is that correct?
Yes, that's right. I attached this to my report.
Okay.
So what I have indicated with this blue shading is potential flood extent during a 10-year recurrence interval event. I took what the engineer had calculated for potential runoff volume, and if this system that it discharges into does not have sufficient capacity, this area shaded in blue represents the majority of the area that would be flooded. It would have approximately 1 foot of water ponded over this area that extends from sidewalk to sidewalk, just because of the buildings on both sides of Ocean Avenue. It would run a little further south on Ocean Avenue than I had survey data to show, as well as a little further west on 7th Avenue in that 10-year event.
Okay, so this exhibit with the blue shading, you're the one who colored it blue, right?
I did, yes.
So I have a granddaughter who could have done that. You could have subcontracted it to her. She's 2. But you did a nice job. Now,
Yeah.
and that's supposed to represent the area of flooding
Mm-hmm.
if the system is misdesigned. Am I
Yes.
correctly characterizing that?
That is fair.
And that would be if it's misdesigned following a 10-year storm event. Is
That's
that
right.
correct?
Mhm.
Okay. How is it that, and so what geographic area are we talking about? I see Ocean Avenue.
And
What
it
else?
covers the sidewalks on both sides of Ocean Avenue as well.
Okay, and what's the depth of water under those circumstances? Can
It's
you
about a
predict it?
foot of water in the road and then a slightly less on the sidewalks.
And this is a 10-year storm.
Yes.
Is the frequency of 10-year storms only once every 10 years?
No, a 10-year recurrence interval is kind of a misnomer. It has a 10% chance of occurring at any given time, just like a 100-year recurrence interval has the chance of happening 1% of the time. So people always say, well, how come we've had 200-year storms in the last 2 years? Well, because it's just there's a 1% probability of that happening. Just in this case, there's a 10% probability of this happening.
Would you describe the data that you relied upon in determining how much you should color blue on that exhibit?
Yeah, so I use the predicted runoff volumes from the applicant's engineer, which are included and detailed on page 7.
Okay.
And then I utilized this base survey where they picked up top of curve, bottom of curve, roadway elevation, all the topography information from this to actually lay that volume out on the surface.
Okay, and the blue only happens, as you're testifying, if the system isn't designed correctly. Is that correct?
That's right. That would be a worst case scenario.
You've been doing this for how many years?
About 20.
Have you ever seen what happens when stormwater systems aren't designed properly?
Yes, many, many times. Frequently, I run into situations where I'm called in after something has been constructed where they were told that it was going to function well and that everything was going to be fine from a flood perspective, and then they have a significant rain event and it isn't fine. And then I have to help, whether that be a municipality or in some cases a homeowners association, to come up with what's called a stormwater retrofit in an attempt to address flooding. It's one of the main reasons why New Jersey's Soil Erosion and Sediment Control Act has the standard for offsite stability in it, because there have been many instances where erosion was caused offsite when you don't have, a paved section next to you. It kind of goes towards wanting not to push stormwater runoff just to the next downstream person, but actually be responsible and address the volume.
Manage it on site effectively.
Yes.
Is that correct?
That's right.
Okay. I don't have any other questions for you. I'm sure the board very well might, and my esteemed adversary, my applicant's attorney might as well as some in the back. So, but for now, I have nothing further for you. Thank you.
Thanks.
Who's next, the board, or how do you do that?
We can deal with applicants' witnesses. I assume if does the board want to ask questions or wait till the applicant's attorney is finished?
We can wait.
Yeah, I would suggest you wait,
Yeah.
because this way you never know
We don't
what
know.
questions and what information you receive.
All right, then let me get, can we switch or something? Do we switch so I could just?
Do you want me to
yeah.
switch there?
Sure, yeah, you're right. Okay. Not really.
Lost the water. There's a cap on it.
All right. Right. Thank you. So before I begin on the line of questioning that I had intended, I do want to ask some questions about your time from 2004 to 2006.
Sure.
Who were you employed by at that time?
That was with Princeton Hydro, and we were contracted with the city of Asbury Park to help them with some of the stormwater rules when they first went into effect.
So you worked for the city of Asbury Park.
That's correct.
And were you involved with the design of the stormwater system in
Not
this
at
part
all.
of town?
No, not at all. I actually wasn't even aware of this until this project was brought to my attention just this year.
And what was the scope of your work at that time?
So I worked with Brian to look at their sort of maintenance plan for the stormwater pollution prevention side of things, and also to walk him through the model ordinance that the state of New Jersey had released. I did not participate in actually writing their ordinance. I just offered him advice as he was going through that himself.
Okay, thank you. Now, there was a prior report that you issued in this matter dated May 25th, 2019. Is it accurate to say that that report has been superseded by the December 4th, 2019 report?
Yes, because there was a number of changes, some of which addressed some of those May comments. So yeah, the December report is my latest.
So if you had a concern that was mentioned in the May report and it's now not mentioned in December, are we to assume it's been resolved?
Yes.
Other than Asbury Park, have you worked on any other matters along the coastal shoreline here in New Jersey?
Yeah, I have done work in Lacey Township as well as Cape May and some of the other areas along the coast.
In the past, let's say 3 years, have you been involved in anything here along the shoreline?
Not with planning board testimony, but design work, absolutely.
And what kinds of projects were those?
I have done living shoreline design work as well as some stormwater retrofits.
Were any of those for planning board applications for individual buildings?
No, all of those were like residential and things that didn't require a planning board hearing.
Right. So can you tell me what the definition under the, generally, not word for word, but generally what the definition of a major development is under New Jersey's stormwater management rules?
Absolutely. Major development involves increase of impervious surfaces by more than 1/4 acre or 1 acre of overall disturbance.
Is it correct that if an application does not increase impervious coverage by more than 1/4 acre and does not involve disturbance of more than an acre overall, that it is exempt from the New Jersey stormwater management rules?
It can be. It depends. Some municipalities have ordinances that require smaller areas to be covered, which is why they gave the model ordinance out to the municipalities. But yes, from the state level, you are exempt from needing a review if you're under those thresholds.
And does Asbury Park have an ordinance that requires review?
Something smaller, no.
Is this application, as proposed, a major development?
It has the potential to be considered that. I know there's this impervious cover question and whether the decking meets the definition of impervious cover. But the way it has been presented, it's over the 1/4 acre because that was assumed in the calculations done.
So do you agree if the decking around the pool is considered pervious, that this application would not be a major development?
It would be under the 1/4 acre threshold, yes.
And therefore not a major development?
Yes.
And is it also true then that if the decking were pervious, that the application would be exempt from the New Jersey stormwater management rules?
It is, however, it goes back to my comment that I made about an engineer's responsibility. So I would argue that, again, going back to the soil erosion and sediment control standards, which go into effect for anything over 5,000 square feet of disturbance, that you would be responsible to still prove that you're not providing an off-site issue.
When you say responsible, do you mean that responsible, you believe, from sort of a policy perspective or under the regulations?
From an engineering obligation, when you are putting your signature and seal on the plans, to be responsible for not causing off-site flooding, because that goes under those New Jersey Soil Erosion and Sediment Control Act requirements. So they are also looking at that when they review soil erosion and sediment control plans for things over 5,000 square feet. They may not be specifically looking at the stormwater calculations, but they are looking at impacts off-site.
And when you say impacts off-site, soil impacts or stormwater
It's
impacts?
erosion related, however, that is directly linked to stormwater runoff. When you concentrate runoff, it can create erosion.
erosion as to the paved street in front of the proposed development?
It could be, or even the discharge point. Again, with this system, we don't know enough about where it's discharging, so I don't know if it's below the water level in Deal Lake or not.
So tell me what you do know about the system that is in the street that's off-site. Where does it start? Where does it end, to your knowledge?
Based on what the applicant has provided, and I have not walked through this whole system or done my own independent calculations, I've relied on the applicant's engineering calculations. It goes into catch basins on Ocean Avenue and then heads north towards Deal Lake.
Okay. And along those lines then, this is actually jumping ahead a little bit for me, but when we look at the exhibit that you had drawn on with the blue,
Yeah.
did you look at the elevations anywhere beyond the intersection of Ocean Avenue and 7th?
Just what is available from free information online, which is not that great when it comes to street elevations. I mean, honestly, you would need more detailed survey. And because there's not a good as-built for the sewer network and the roads, in order to really have a good handle on that, it would be something that would require some additional points, which is why I made the comment I made where I would go out typically with a surveyor to say, here's the boundaries of where I want you to pick this up to get it properly characterized.
So when you colored the exhibit blue, what assumptions did you make about surrounding elevations of the inlet system?
I didn't make any assumptions. That's using the information on that base to predict if I had to put the entire volume of what your engineer had put together on the surface of the ground. The percentage of everything that would fit there, that is the area it would cover on the surface.
So is that assuming that none of it goes down into the existing inlets?
That's right. That's assuming that nothing fits into the pipes.
But there are existing inlets out there.
There are.
Would that exhibit still be colored blue the way it is if the inlets actually accepted water into them?
No.
And do you have any knowledge of what it would look like if the system were functioning out there?
If the system were functioning for a 10-year event, everything would fit into the pipes, but the applicant's engineer has not provided enough information to say that it can.
So going back to your letter.
Sure.
Shuffle, there it is. Okay. So this next set of questions I'll ask you is based on an assumption that it is a major development, which you indicated it comes down to whether the decking is pervious or not, as to whether it's major or not.
Yeah.
But even if it were a major development, you mentioned that the applicant is assuming that no groundwater recharge is required since the site is located in State Planning Area 1. Do you agree with that statement?
Yeah, it's not required for that reason, and frankly, with the potential for the landfill material there, it would also be something that the state would not want to see infiltration for.
But the landfill material is going to be removed,
That's
correct?
right.
And so is infiltration a problem once the landfill material is moved?
No, I mean, down in this area on the coastal plain, there's so much recharge under existing conditions that maintaining it is a good, responsible engineering thing to do.
Maintaining what?
The recharge. So there's existing recharge that happens on the site right now, given that there's no pavement on it. Water's just able to pass into the sand.
And so by removing the construction debris, would that increase the recharge and infiltration?
It's hard to say because of that groundwater question and the perched water table. Without knowing more about those characteristics, it's tough because there's this material there that hasn't been taken out. You really wouldn't be able to know what the infiltration amount is without monitoring post-construction.
But you would agree, again, no groundwater recharge is required?
No.
Okay. You mentioned here that all water quality systems installed as part of the infrastructure improvements are sufficient to treat runoff from the project site, that was an underlying assumption.
That was exactly what the applicant's engineer indicated, and I know when they put the systems in that they put water quality systems in to treat runoff going into Deal Lake because it is a sensitive water course. There's the Deal Lake Commission that regulates that. So I know those systems are in place, but again, I don't know about functionality of the ones that are connected to this particular system.
But you have not identified the need for any additional water quality treatment systems for this application?
No, recharge typically provides the required water quality measures if you were to need water quality treatment.
Okay. So there's no issue with recharge, no issue with water quality. Are your comments limited then to the water quantity aspect of stormwater control?
That's really where my biggest concern is with this application, yes.
Okay. And the underlying assumption for the applicant you characterize as no water quantity controls required because the site drains to tidal waters. Am I accurately summarizing your presumption of the applicant's position?
Yeah, I mean, with regards to that, you had DEP ask in that November email for stormwater quantity control as well, and the applicant's engineer provided that analysis on the 76% versus 90% impervious. However, I feel that the calculations are not complete enough to justify that quantity has been addressed. Now, I know, you know, if you were to say that this is not a major development, you're going to tell me that it's not required, but again, it goes back to a responsibility. I mean, leaving the site knowing that you're going to increase flooding is an awfully ethical dilemma, and we have an ethical obligation as professional engineers not to create problems.
But under the existing administrative code, if it's not a major development, then no quantity control is required, correct?
That is correct.
And under the administrative code, if the site drains to tidal waters, is quantity control still required?
It can be required if there's a potential to cause off-site flooding.
But if there's no potential to cause off-site flooding, then there's no need for quantity control. Is that correct?
That's right, but we don't have enough information to say that we're not going to cause off-site flooding, which is the point of my report.
So just kind of narrowing down the universe then, your comments are within the bounds of assessing quantity control when it comes for potential for off-site flooding
Yes.
for major developments.
Mm-hmm.
Yes, right?
Yes.
Okay. There was a question asked in here about the Phase 5 improvements. Are you aware that the Phase 5 improvements for the pathways on the boardwalk generally are currently under construction?
Yes, and so I would just be concerned about completion of an as-built to verify that that drainage is directed into this system.
So it's not an issue of redesigning, it's just an issue of verifying upon construction?
Yeah, I mean, it goes to my point with many of these projects is the maintenance and the way that they're as-builted, and frankly, one of the reasons this problem even exists and why we're talking about off-site flooding is that there was not a proper as-built for some of the city's systems, which is so typical for these projects. The as-builting part gets neglected, and then we don't have a good baseline to measure against.
So you're saying that you don't believe there was an as-built performed on the city's system?
Not that I'm aware of.
Okay. And you're not aware if there was a off-site stormwater plan prepared and submitted?
I am not aware of one either.
And
No,
you
I
did-
haven't seen that.
You did not review one in connection with issuing this report?
No.
Okay. I think that's all I have at the moment.
Okay.
Any questions from the board?
So if I can, for number 2, you had mentioned in the testimony that the TR55 method was an RSIS standard and that was inappropriate or incorrect. But then you'd also mentioned that there is no standard for this type of development. So is there another standard that would be typically used, or
There
is there
isn't.
not?
There is not a standard that's typically used. Typically, the municipal engineer, in this case, planning board engineer, would say whether they felt 10 minutes was sufficient for the site.
Okay.
And that's the way it's done for developments that are non-residential.
And then the same for number 3. There were some concerns about using a 25-year recurrence interval to analyze the runoff. Is there maybe this is more a question for our board engineer? Is there a standard that should be used besides the 25-year?
Do you swear that from the testimony given during these proceedings will you retrieve the whole truth and nothing but the truth?
I do.
State your name and
Jason
affiliation.
Fisher, board engineer. 25 year is pretty common.
Okay. Thank you. And number 4, you mentioned you testified a little bit about the pipe slopes and how they were analyzed at 5 and 3%, but the plans show them a little less slope
Yeah.
than that. Is there any idea you have about what kind of percentage impact that might have on the?
No, because I didn't run any of my own calculations.
Okay, thank you. That's all I had.
I have a couple of questions regarding operations and maintenance, and then a question about soil replacement. So when you mentioned that to better test the capacity of the system, that you would advise, I think you said vac, but like
Yeah.
vacuuming in or out, who would be responsible for that vacuuming?
For something like this where it's a developer coming in that needs to rely on the connection, that's done by the developer's team. But other times I've seen, the municipality agree to do it if it's on part of the rotation for your planned backing of catch basins.
And I agree, making sure that those pipes are kind of working in full capacity matters, but who's generally who owns the system and who's generally responsible for vacuuming?
The city.
Yeah. You did have a comment on page 7, which I don't think you necessarily spoke to in your testimony, but it said that no stormwater maintenance information was provided by the application.
Yeah.
Especially for the proposed underground detention basin. Can you describe the kind of type of stormwater maintenance that you would expect to be provided?
Absolutely. So I don't know enough about what's proposed here. I know there's a detail for cleanouts that's shown on the applicant's plan. So what I would envision is that somebody from the city, if this is turned over to the city or the beach club themselves, they would have someone on staff who opens those cleanouts, basically shines a light down there, sees if there's water, measures the water level, and makes sure that it's draining out within the required 72 hours. These are systems that are supposed to drain within a 72-hour time period after a rain.
And that's pretty standard. 72
That's pretty
hours is what
standard.
you would
I mean,
expect.
that would be the typical maintenance. If there was a clog and you ran into an issue, then you're talking about needing to potentially do excavations and replacing things and running engineering analysis. But that would be, in a typical stormwater maintenance plan, would be the more unusual maintenance conditions.
And I mean, there's no way of saying this because it's not fully modeled, but you think if the condition of the system were to be brought up to full capacity, that the flooding that you indicated on Ocean Avenue wouldn't happen with, let's say, a 25-year.
Yeah,
or 10
exactly.
years.
If that pipe capacity is verified all the way to the discharge point, then you wouldn't have the nuisance flooding on site unless some clog happened elsewhere in the system, which obviously wouldn't be the applicant's responsibility, but
Okay.
yeah.
Thank you.
Mhm.
And then one other question about soil replacement. So you said that probably due to what came out of kind of the borings and testing and hitting of some kind of debris, that the applicant has revised to doing soil replacement, I think you said to 8 feet. But is that, just so I understand clearly, the elevation that they would go to with that soil replacement is 2? And then typically, well, 2 things. What happens in order to bring the site back up to its kind of natural elevation, which is sloped now, but from the 2-foot point, what happens to kind of, I think the lowest elevation on the current is maybe at 7 feet or something, but what makes up that difference?
So basically they're putting in sand that has a certain permeability rating. It's just like if you were looking at a septic system. It's
Right.
pretty much the same idea. You dig everything out that's there. They're hauling that off site, I assume, to somewhere that's licensed to take waste, and then bringing in certified material that meets a certain permeability rating.
And how do you ensure that that soil replacement isn't so compacted that it can't absorb any of the water that you've anticipated based on the current depth of the groundwater?
So typically there would be notes added to the drawings or in the specifications when it goes out to, if it goes out to bid, that indicate how thick the layers of soil need to be placed and whether they're allowed to drive equipment and with what weight ratings over the system. If they drove over it with really heavy equipment as they're placing it, if there's no information provided, it won't infiltrate anything because it'll be too compacted, especially with that amount of soil.
Okay. And then I guess the final thing is what, kind of using that soil only to the 2-foot elevation, I'm not clear, like, what kind of assurances or what kind of monitoring would happen to kind of make sure that the site wasn't additionally kind of meant to go to a certain elevation, but being additionally built up in order to kind of send stormwater off-site?
Yeah, there's not anything that would be, unless there was a condition of approval or somehow included in the, the property maintenance manual or some other legal way to assure that nobody's going to build on top of it. I don't think it's getting deed restricted. At least I didn't see that on any drawings, but maybe it is. That would be a way to ensure that nobody builds up on top of the system and impacts its functionality in the future.
Okay, thank you.
Sorry, I had one more additional question on the soil replacement. So
Yeah.
it was discussed that 8.5 feet would be replaced,
Mhm.
right? But that in the, I guess, survey or soil borings, that there was an issue 4 feet below grade with refusal. If the applicant was proposing to take out 8.5 feet, wouldn't that potentially cover the whatever refusal was happening at 4
So
feet?
that's a great question. It might, but it's a little bit unclear. So if you have like a perched water table that extends far off of your site boundaries, even though you're then like slicing out the section and replacing 8.5 feet of soil, water could still come in from the area outside depending on how large the perch
Kind of
area
off-site
is.
impact, okay.
Yeah, I mean, like I said, when you're looking at a site like this, usually you try to poke a lot of, and this is a tight space, so I know they'd have challenges, which is why they use borings in addition, but you would try to isolate where that is, and that would be something the geotechnical engineer would typically do.
Thank you.
Any other questions from the board? Any questions from our professionals? All set? Okay.
I had one
Go ahead.
procedural question. Does the other engineer come back or no?
We will be bringing Mr. Delaney back probably at the next meeting because of the timing to address some of the issues in this report.
And I believe that the board also has the right to call back anyone that, because of the timing of when we receive the report and the presentation, because usually we would have it weeks ahead as opposed to days ahead of the meeting. So we would also reserve the right to be able to call people back if we needed further information, if we felt we did. Okay?
Correct. I'm getting a nod of approval from Mr. Lieberman, and I'm sure applicant's counsel agrees to that as well. Yeah, that's correct.
Okay?
Process. We need to talk to witnesses again.
I just had 2 redirect. If you want to do it now, or do you want to?
Why don't we wait till afterwards, because it may change the order. Questions from the public, so.
All right, so what I'm going to request is that if we have a 5-minute recess, and then we will come back with public questions, and let's please keep it to 5 minutes. Thank you.
Yeah, switch back.
Motion to recess for 5 minutes.
Second. Aye.
That's not.
8:40 p.m. Mayor John Moore.
Here.
Michael Manzella.
Here.
Jennifer Sauter.
Here.
Alexis Taylor.
Here.
And Barbara Kennedy.
Here.
Thank you.
Okay, time for public comment? I'm sorry, public questions? What?
Question.
Cross-examination of the witness.
No, what you
Yes,
said's right.
That's what I meant.
Yes.
Yeah.
That's what I meant, not in a formal way. Okay. All right, cross-examination, public questions, please. Up to the microphone. Please, let's just try to do it one time around, just to make sure everybody gets a chance. Now, this has to be cross-examination for what was discussed by the witness. I mean, by the professional.
Madam Chairperson, when you say cross-examination question,
To what was presented today, what was testified today.
I'll wait. This is directed at the board. I'm sorry.
Okay. Okay, no problem. Okay, any questions? Any questions for, okay,
Motion.
No, wait.
Oh.
You gotta go to the microphone.
yes. Can you come just a little closer, your name and your address, please?
Marion Ercolano, 1501 Ocean Avenue.
Ma'am, you need to speak up, I'm sorry.
Sorry, Marion Karani, 1501 Ocean Boulevard Avenue.
Just a second, it might not be on, hang on.
I see a screw.
As long as it's not loose.
Okay, so I'll start again. Can you hear me?
Yes.
All right, Marion Karani, 1501 Ocean Avenue. Just a quick question, and I guess the only relevance it has to what you spoke to is water. So in the sense of water, what happens in the event of a big storm and we have a pool with lots of water? Is that something that's been taken under consideration in the study of what happens with that drainage?
You mean from the pool, swimming pool itself?
Yeah.
I don't think it was specifically addressed by the applicant's engineer, but that goes to my point about what happens to water that exceeds the capacity of the pipe system, and that wasn't addressed by the applicant. So I'm not sure exactly where, you know, water would go for larger events outside of what they designed to.
Okay.
Thank you.
Mhm.
Hello, Warner Baumgartner, Fifth Avenue. Just a quick detail about permeable versus impermeable. There was some testimony about whether the deck is permeable or not. I didn't hear anything about the upper levels, the second floor, the partial second floor, and the walkway that partially surrounds that. How was that addressed?
I don't think there was anything specifically calling that out. Everything in the engineer's report assumed everything was impervious. In terms of my opinion on the decking being pervious or impervious, I would state that it should be considered impervious, given that a significant amount of construction has to happen to construct all of this infrastructure. And there was no documentation provided about, you know, making sure that they're not compacting subsoils and things. So everything's going to act impervious.
You're aware that there's a concrete apron around the pool itself, right?
I believe that is what is on the drawings.
Okay, and that would be considered impervious, obviously.
Yes.
And then the rest of it is what, an open deck, like a porch deck where the water falls through?
As far as I know, yes.
Okay. And the second floor, you did testify to some extent about roof runoff, you called it. What are you characterizing as roof?
Again, that gets a little bit vague just because of the structure itself. It's treated more as the overall footprint of what the applicant has claimed is the impervious surface. So they have mapping included in their report that goes through the drainage areas and how they calculated those, and they have deemed those as roof areas for purposes of analysis. I can't really speak to how those were decided, but they have it mapped.
Okay, and according to the data that you received, all of the runoff from this height will travel north toward Deal Lake?
Into that system that runs to the north, yes.
Thank you.
Anyone else from the public? No other questions?
Motion to close.
Second.
All in favor?
Aye.
Aye.
Can I make a comment?
No, it's not comments.
Okay.
No, you don't have to close it, it's just that there's no other witnesses from the public, it's your turn to redirect.
To redirect, okay. So I just had two questions based on the testimony and the questions. There was a characterization by the engineer for the board that 25 years is general, is standard in terms of the storm event?
It's standard for the pipe system because it would be extremely cost prohibitive for municipalities to construct stormwater systems that can convey runoff from events larger than a 25-year recurrence interval. But my comment is not related to whether that's an appropriate standard. It is related to what happens for events larger than that, which is typically and standard of practice required for an engineer to look at. And they analyzed events larger than a 25-year event. There's just no documentation of where that water travels.
Okay. And there was also a question by a board member concerning the time of concentration. right? And there was an acknowledgement by you that the only standard that's out there is for the residential standard. Is that correct?
That's right.
Does that in any manner change your testimony, or what's the bottom line of your testimony as it relates to there only being one standard, and that's for residential?
Yeah, because there's only one standard for residential, and I would argue that it's, again, I made that statement in my report that that's for the rational method and not for the TR55 method. Just because there isn't a standard does not absolve me or any other professional engineer from actually completing the calculations to determine the time of concentration to do the analysis correctly. So again, it's an engineering practice to calculate a time of concentration unless you have very good justification to explain a 10-minute time of concentration.
And by the way, the 10-minute time of concentration, is it correct that that applies to a methodology that wasn't even employed by the engineer in this case?
Yeah, that's right.
So in other words, even if there was a standard for residential and for nothing else, that discussion is actually irrelevant to this case because the methodology where that would apply wasn't used here. Is that correct?
Yes, that's right.
Okay. All right. Well, I don't have anything further at this time. Thank you, everybody, for your courtesy.
Thank you.
So I would ask that this exhibit 05 be introduced then. Yeah.
Any objections, counsel?
No, I assume that we're going to, at the end, go through all of the exhibits to move them all together, but I have no
Well,
problem, this
it
will be
doesn't
put
matter.
in.
If he
Yeah.
wants to move it in now, it's fine.
Or-
That's fine.
Or if nothing else, let's mark it for identification and give it to the court reporter for.
It's
yeah.
marked.
Okay, and you'll hold on to it then. Is that how we do so? Okay, very good. Thank you very
Yeah,
much.
so
Okay.
it's fine with me. Either you can do things individually, or if at the end, everything both of you submit to move into evidence, that's fine.
Correct.
That's
I think we're up to 50-something exhibits on my end, so I plan to do that all at once.
If you haven't done individual, then
Yeah.
just do it collectively at the end, just so let's not forget.
Why don't we
Sure.
talk about it before the next meeting? Just
Okay.
hold it. Okay, very good.
Yeah, that's easy.
Okay, so thank you. I don't have anything further then for you. Thank you very much. You're welcome. Okay, so our second and last witness is Carlos Rodriguez.
Please raise your right hand. You swear or affirm the testimony you give during these proceedings will be the truth, the whole truth, and nothing but the truth.
I do.
State your name for the record.
Carlos Rodriguez, Rodriguez.
Thank you.
Okay, good evening, Mr. Rodriguez.
Good evening, Mr. Lieberman.
You're a professional planner licensed in the state of New Jersey, is that correct?
I am.
And by whom are you employed?
Design Solutions LLC.
Okay, and before we get further into your background, you prepared a report which has been identified as 06, that's dated that was sealed by you on December 4, 2019. Is that correct?
That's correct.
And the report that's going to go into the record is sealed by you and it's signed by you. Is that correct?
That's correct.
Okay. You tell the board about your.
And before we go into the qualifications, I do have additional copies of the report. I assume that the board has copies.
The board has copies.
The professionals have copies.
Yep.
The applicant has copies, in which case I will make these available to the public. If they have any interest, I'll just put them back here. Anybody who wants them?
That's 06, correct?
That's 06. Okay. I don't think you're going to be able to sell them though.
Probably not.
Mr. Rodriguez, how long have you? What is your position at Design Solutions LLC?
I'm the principal.
Go ahead.
I'm the principal.
Okay. And how long has, and what the business is Design Solutions in?
It's in the business of planning and design consulting.
How long have you had that?
I'm sorry, could you just get closer to the microphone, please, or the microphone closer to you? Thank you.
Planning and design consulting.
Okay. How long have you had that business?
I think for the last 3 years.
Okay. Before then, by whom were you employed?
By myself.
Okay. And
It just wasn't an LLC.
okay. And how many years were you employed by yourself?
Probably 5 or 6. I've worked for a number of organizations, including the state of New Jersey, architecture and planning firms, regional planning, not-for-profit organizations.
Have you been recognized as an expert by any planning boards or zoning boards of adjustment in New Jersey?
More than I can remember.
And do you currently work as the planner for any zoning boards or planning boards or governing bodies in New Jersey?
Just one planning and zoning board. It's actually a combined board.
And that's Bound Brook, is that correct?
That's correct.
Okay. And your license is currently in effect, is that correct?
Yes.
Okay. At this time, I request that Mr. Rodriguez be accepted as an expert in planning. He is a professional planner.
And there is a synopsis of my qualifications as the last page of the report that was submitted as an appendix.
I just have a few questions. The first, are you...
Already?
I do, just as to your credentials. Are you licensed as an architect in the state of New Jersey?
No, I am not.
Are you licensed as an engineer in the field of traffic design in the state of New Jersey? A traffic engineer?
No, I'm not.
Okay. And have you ever done work here in Asbury Park or for Asbury Park?
Not to the best of my recollection.
Okay.
I mean, define work. Paid work?
Paid work.
Paid by the city.
Paid by the city or involving any property here in Asbury Park?
Well, so going back many years, a firm, and I mean many years, a firm that I was working with did work in Asbury Park. This was when Mr. Carabetta was the redeveloper. I was not the planner on the job.
And was the firm employed or retained by the redeveloper?
Yes.
And was that Asbury Partners?
Carabetta.
It was Carabetta. And did you yourself participate in the creation or drafting of any studies?
No.
Okay.
No. I did not get involved with that. That was a very messy, situation.
Suffice it to say you didn't get involved with that, is that
I was
correct?
not involved. I was glad not to get involved with it.
Okay.
I was involved in trying to collect our fees from Mr. Carabetta.
Okay.
Using an attorney, and we did get something in the end, but that obviously was not was a story that did not have a happy ending.
Okay. And Mr. Rodriguez is being offered only in the field of professional planning, is that correct?
He's being offered as a professional planner.
Okay. Thank you, that's all.
So, but to further answer your question about the architecture thing, I do have an architecture degree. I don't practice.
And you
I
are not
did-
licensed?
And I'm not licensed, but I did go through a 5-year architecture degree program.
But you're not being offered as an expert in the field of architecture, is that correct, Mr. Lieberman?
He's not being offered in the field of architecture. He's being offered in the field of planning, and he will testify in the areas that planners traditionally testify about.
Thank you.
You're very welcome. All right.
Go ahead. So.
Well, wait,
Let me ask the question.
I have to ask the first question,
Oh.
and then you can go ahead.
Now,
Mr.
wait, let's get on the record. Does the board accept his credentials?
Yes.
Yes.
Okay, now you can ask your question.
Okay, very good. Let me get closer to the microphone. Okay, so, Mr. Rodriguez, you were asked to evaluate certain documents and to offer an opinion in this case. Is that correct?
That's correct.
Okay, the documents that you reviewed, are they itemized anywhere in your report, or can you characterize them for the board?
They're not itemized per se. There are a number of documents that are referred to throughout the report, but I did not itemize the entirety of what I reviewed.
Okay. And this report does contain the sum total of the opinions that you're prepared to offer in this case. Is that correct?
That's correct.
Okay. Why don't we go through your report and in summary fashion, sufficient enough to inform the board and the applicant, explain what your opinions are and the factual or planning basis for those opinions. Okay, what page are we starting with?
Well, I think we can skip the introduction, which is just a factual description of what's being proposed, and we can start with section 2, which is a discussion of whether what's being proposed is in fact a beach club as is being represented, or whether it's something else.
Okay.
So I start by noting that there are no definitions either in the plan or in the local regulations for what a beach club is, and as well as a number of other items that are pertinent to the pending application. And so we have to look elsewhere to try to clarify what it is that we're talking about. And I looked at a number of other sources. The first source that I looked at was sort of the industry standard, the leisure industry in particular, and there's a dictionary for the travel industry which is accessible. And so I looked at that definition, and I don't need to read it, you can read it yourselves. I just want to refer to it. I also looked at definitions of beach clubs and pool clubs found in regulations for other Monmouth County towns, and there, as you I'm sure know better than I do, there are many clubs in this part of the state. And so I'm not going to, again, read through these various definitions. You can do that yourselves, but I would just say that the one thing that these definitions all have in common, and this should not come as a surprise, is that they all involve the use of the beach. Now, beach clubs frequently include swimming pools, but they are not in enclosed facilities disconnected from the beach. Some beach clubs also have tennis and other sports activities, such as lacrosse, basketball, baseball, kayaks. Some have restaurants and bars. Some offer overnight accommodation for members. But the one thing that they all have in common is access to the beach and to the ocean, and that's an integral part of the model, and that's why they're called beach clubs. Now, if you do a simple Google image search for beach clubs, you'll find thousands of images from all over the world. Many have pools, but there's no separation between the pool and the beach. And ready access to the beach is always expected and provided. It's the one thing, again, that all beach clubs have in common. By contrast, the applicant's proposal is for a building with no direct access to the beach, and in fact, with no views of the beach, except for a limited section on the upper level. So the proposed facility is entirely inward looking, entirely organized around the pool and the food and beverage area. It happens to be located next to a beach, but it has no functional connection to the beach. And the location next to the beach is frankly irrelevant in terms of its functionality. Indeed, it could be located anywhere in Asbury Park and still function as intended. So the conclusion that I draw from these musings is that the applicant's proposal is for a pool club, not a beach club. There is no indication that membership in this pool club will grant access to the public beach. Members of the pool club would have to acquire beach passes from the town in order to gain access to the beach. In fact, they'd have to go out the front door, get on the street, and then cut across to access the beach, the roundabout way. It's very clear that by the location of the front door that you come in and out without ever going to the beach. So it seems to me that what's being proposed is really a private pool club where wealthy individuals can socialize, eat, drink, and take some sun, catch a fleeting view of the ocean from the upper level deck at a safe distance from the crowds that are on the beach. Now, why is this relevant? and in section 3, I go into the question of whether a pool club is a permitted principal or conditional use under the plan. So beach and fishing.
Which is on page 9 of your report. So that's where you are now? You're on page 9?
That's where I am now.
Okay.
So beach and fishing clubs are permitted conditional uses under section 3.8 of the plan, provided they don't block access to the boardwalk. However, there's no mention of pool clubs. And as you know, uses that are not listed as permitted or conditional are not permitted by default. Now, this is a significant finding because the redevelopment plan does talk about beach clubs and swimming clubs. So why would it fail to mention them? And it talks about pool clubs, as a matter of fact. Why would it fail to mention them in the zoning, in the permitted uses? So my conclusion is that pool clubs are not a permitted principal use or conditional use anywhere in the redevelopment area, and that this application is in the wrong jurisdiction and in fact should require a use variance to be considered by the zoning board. Ultimately, and in this section I talk about how the plan deals with various aspects of the plan, deals with this location and the possibility of some kind of a club there. Admittedly, the plan, the various elements of the plan are not entirely consistent. Some maps show something at this location, some maps don't show anything at this location. When something is shown at this location, it's not identified as a beach club or a pool club or anything else. It's not identified, except in one map where it's identified as a pavilion without a particular purpose. So the redevelopment plan is a little bit shaky with respect to this. And ultimately, the question of whether the pending application is for a beach club, as the applicant contends, or for a pool club, as we're suggesting, and whether a pool club is a permitted conditional use, again, as the applicant contends, is a matter for this board to adjudicate. We believe a pool club is not permitted under the plan, as it is not synonymous with beach club, which is permitted. So that's the argument as to the question of whether a pool club is a permitted use. In section 4,
page 10.
Yes, I go into the question of whether a membership pool club as proposed is permitted under the CAFRA permit. So there's also a question of whether the pool club would violate the town's area-wide CAFRA permit. I believe that it does under two separate counts. First, the CAFRA permit does not anticipate a membership-only pool club next to the beach. And second, the lack of parking that, as proposed by the applicant, also violates the CAFRA permit's provisions regarding parking. And I discussed that, we'll discuss that in a minute. If you read the CAFRA permit, and the CAFRA permit, by the way, like the redevelopment plan, is not the clearest document. There are typos, there are contradictions, etc., but you can get to the gist of it. And at page 12 of the CAFRA permit, it reads, while the program has not yet had an opportunity to review plans for either of the two public beach clubs, emphasis on public, it's expected, an emphasis on beach clubs, it is expected that the second story will serve as a changing/shower area with the boardwalk level to serve as commercial space. So this is a facility, obviously there's no pool on the ground floor. This is a facility where the ground floor has a restaurant, has changing areas, has et cetera, and an upstairs area. The upstairs area has changing and shower areas and so forth. There's no mention, and no room, frankly, for a pool in this club. If you really read the CAFR permit and get past these minor contradictions, it's clear that the expectation is for a public beach club to be built at the proposed location, not a private pool club. And this would be consistent with the use of the term reestablishment, which on page 1, the CAFR permit mentions reestablishment of private and public beach clubs. So it would be consistent with the use of this term, as it's known that a public beach club existed in the past at the location of the now proposed private pool club. The boardwalk level, i.e. the ground floor area, is to serve as commercial space for food and beverage, changing rooms, etc. It's not to be occupied by a swimming pool surrounded by deck chairs and cabanas. The expectation in the CAFR permit is that the members of the public beach club would be on the beach, not inside some building, like they are at every legitimate beach club. Now, the clubhouse could offer added amenities such as changing rooms, private showers, lockers, food and beverage, etc. to the public for extra charge. But on balance, I believe the CAFR permit intended for these facilities to be public. This would be consistent with the emphasis that CAFRA places on facilitating public access to beaches and to the waterfront under New Jersey's long-established public trust doctrine. So, on balance, I find that what's being proposed violates the CAFR permit. Now, in section 5, which is on page 11, I go into the issue of parking. And ordinarily, I would be the last person in the world to raise a parking issue, but in this case, I feel like I need to. So the application claims that it's exempt from the town's parking requirements, and the basis for this alleged exemption is that the redevelopment plan on page 50, there's a section on parking, lists a number of commercial uses that are not required to provide off-street parking. And these is a significant number of uses. But neither beach clubs nor swimming/pool clubs are part of the list of exempted uses. So it's not obvious to me on what basis a private pool club, such as proposed, should be granted an exemption. Unless it's considered a place of assembly, which it might be. And again, that's that's a determination for this board to make. And I provide here with some information some definitions, which I take from actually the building code, which I find to be a useful source for these sorts of things because it combines buildings with uses. And you can read all of that for yourself and make up your own minds. But regardless of what determination you make there, it's apparent to me that the absence of parking to support the proposed use clearly violates the terms of the CAFRA permit. And the plan, in its discussion of parking, itself recognizes that one of CAFRA's main objectives is not to preclude day trippers from being able to find a place to park. That's at page 47 of the redevelopment plan. Now, there's no reason to believe that the majority of the members of this proposed pool club will arrive by any other mean than a private motor vehicle. We haven't heard any testimony on how people are going to get to or from this pool club. And similarly, there's no reason to believe that a majority of the staff that would be working at this proposed pool club will come to work by means other than the motor vehicle. Although admittedly, that could be somewhat more plausible. Now, while Asbury's Land Development Code does not define places of assembly, it does contain a parking standard for places of assembly. And that's section 30-59.5 of your land use regulations. That standard is 1 parking space for every 5 seats. We heard testimony that the proposed club's capacity would be 400 people as per the fire code. And presumably that includes, I don't know, 50 to 75 employees as well as patrons. So according to that standard, they would need 80 parking spaces. The town's parking standards also have a standard for private clubs, including swim clubs, which is even more stringent. And that's 1 space per 4 persons. So that would be 100 parking spaces. So whether the number is 80 or 100 or something in between, the reality is that the absence of dedicated parking for the pool club will mean that the pool club patrons and pool club staff will displace the previously mentioned day trippers, i.e. the general public visiting the beach, not to mention visitors and guests of the good people living in the nearby apartment buildings. When I visited the sites on a Sunday this past August, there wasn't a parking spot to be had within miles. So the displacement of the day trippers violates New Jersey's longstanding public trust doctrine. It violates the redevelopment plan, and it violates the CAFR permit. It would also deprive Asbury Park of foregone revenues from the sale of beach badges and other revenues from expenditures that will not be made by people who can no longer park near the beach and the boardwalk attractions. So the applicant, in essence, is privatizing, or would be privatizing, a public good for the benefit of its membership and to the detriment of the town's residents and daily visitors to the beach and associated amenities. The displacement of the day trippers and of visitors to nearby residents clearly violates the CAFR permit, the public trust doctrine, and frankly it should cause alarm to this planning board, as no solution or mitigation has been offered. You don't have any questions, right? Not
No,
just yet?
I'm just listening to you, but I think we should
Okay.
go to page 13, question of operations. That sound
Okay,
good?
all right. So in section 6, page 13, I look at the question of operations. Now, we know nothing about the proposed operations of this club. The applicant has consistently refused to provide details. We don't know what time the club would open, what time it would close, or whether it would even close, whether it would be open every day or just on weekends, during the season, off-season, whether it will serve alcohol, whether it will be open for private events, if it will have live music, DJs, nothing. Nothing. And yet, pool clubs and beach clubs in other Monmouth County towns are carefully regulated as to operations, in addition to their own, in some cases, fairly strict rules and regulations, self-imposed regulations, which you can access by just looking at their websites, and very detailed. What time we close, what time we open, how many guests you can bring in, blah, blah, blah. In Asbury Park, outside of the waterfront redevelopment area, uses such as fraternal, social, civic, recreational, or philanthropic, or eleemosynary uses, which would include a pool club such as is proposed, are permitted outright only in the light industrial zone and as a conditional use in the B1 zone. And the conditions are that they have to provide a statement setting forth full particulars on the operations of the structure or use, And that's submitted to the planning board by the applicant in triplicate. In triplicate. And in addition, the planning board has to ascertain that the proposed location is appropriate for the proposed use and that the use will not detract from the area or adversely affect the value of adjacent properties. So in other words, if this proposed use, whether you deem it a beach club or a pool club like I'm deeming it, were located outside of the waterfront redevelopment area, the planning board would be expecting a full account of its operations in triplicate. Somehow the location of the waterfront redevelopment area exempts it from satisfying such considerations. I find that hard to understand or accept. Now, planning boards in New Jersey have the responsibility, in fact, the duty to evaluate off-site impacts of proposed uses, whether or not they are permitted, and to require reasonable accommodations from the applicants to eliminate or mitigate any adverse impacts to the neighbors. You know that, I know that. It's literally not possible to determine potential off-site impacts without a thorough analysis of proposed operations. Section 30-73.8 of your land use regulations deals with commercial uses in the waterfront redevelopment area. This section states that uses incompatible with residential development would include uses which would generate large volumes of traffic, noise, trash, offensive odors, or have extensive hours of operation and loitering. Now, it's impossible to address these concerns without a detailed description of proposed operations and procedures. The residents of the buildings adjacent to the location of the proposed pool club are counting on this planning board, if it elects to approve the proposal, to make a detailed assessment of potential off-site impacts and to take measures to eliminate or substantially mitigate any negative impacts derived from this project. But in order to do so, you have to know what's being proposed in greater detail, and you don't, for now. On page 14, I go into urban design and architectural considerations. The first thing I'm going to tell you is that the building that's proposed blatantly defies every architectural standard in the plan, as well as commonly accepted design principles. And by commonly, I mean widely accepted design principles. Now, I don't need to go into the details of all of the things that it violates, but
Well, from a planning perspective, would you have an understanding whether certain waivers were requested as they relate to architectural design?
yes.
Do you have an opinion as to whether or not the standards for those for those waivers have been satisfied?
I don't believe they have.
Would you explain what the standards are and why you don't believe they have them?
Let's discuss some of the reasons behind the requests for the waivers. So, whereas the plan calls for vertical and horizontal articulation in the facade, as well as significant glazing, the proposed building presents itself as an impenetrable monolith occupying an entire city block. Clearly, the intention is to provide no clue to those on the outside of what is going on inside this building. It's like an alien warship suddenly landed on the Asbury beachfront. The blank walls, which by the way are not permitted under, under your design standards, including incredibly the blank wall facing the ocean, so the people in this purported beach club can't see the ocean. They create a bunker effect. The proposed vines, which the landscape architect testified would soften the building facade, would not be needed if the facade were not so unfriendly to begin with. The continuous fence facing the boardwalk and the building's overall appearance of impenetrability indicates in no uncertain terms that the building is off limits to the neighbors, to the regular folks enjoying the public beach, and to just about everyone else as well. Now, the planner for the applicant testified with respect to the justification for the multiple design waivers that the application admittedly needs. The main arguments seem to be that the plan's design standards were intended for multi-story, mixed-use, or residential buildings, not for a two-story clubhouse or pavilion. That's complete nonsense, because the plan, in the design section of the plan, is very clear that it applies universally. But there's a difference. The plan's design standards are contextual. That means that they value the whole more than they value the individual. They recognize that while individual buildings may be visually striking, it is the sum of all the buildings, the sum of all the parts, that makes for a real sense of place. In other words, the sum of all the parts is bigger than the individual parts, right? The whole is bigger than the sum of the parts. Now, vanity architecture, as is being proposed here, dismisses the more contextual approach to urban design. Vanity architecture values buildings that scream, "Look at me, I'm different." And this has nothing to do with style. The plan does not mandate a particular architectural style. It does reference several historical styles, but it doesn't mandate them. It does not seek to force new construction to copy these styles. What it seeks to do, what the plan's design standards seek to do, is to humanize new construction and avoid precisely the type of very unfriendly architecture that's proposed for the pool club. Specifically, the applicant is looking for a relief from standards pertaining to, and this to your question, Mr. Lieberman, windows, voids, solids, fenestration, use of storefront glass, windowsills, building articulation, blank walls, and wall finish. Now, the justification offered by the applicant's planner was that because the pool house has no windows, the window standards don't apply. As for the other standards the proposal violates, the justification seemed to be that the proposed pavilion is a contemporary interpretation, and therefore such rules, again, should not apply. The applicant's planner ignored the fact that all of the standards for which waivers are requested have to do with, as I mentioned previously, humanizing that building and every building by breaking it down into smaller components and thus creating visual interest and variety, not 220 feet of blank wall in every direction. Instead, the applicant has proposed an impenetrable bunker that's deliberately nasty and disrespectful, frankly, of its surroundings. Where the plan's design standards require articulation and visual interest, the pool club's architects prefer monotony and a deadening effect. While windows may not be appropriate in the changing room area, as testified by the applicant's planners, by the way, window treatments are not an option. The plan standards do not mandate the use of clear glass. Frosted glass would both address the solid to void requirement, the window requirement, provide privacy, and introduced variety in the facade. Frankly, I didn't hear any substantive reasons to justify the need for the waivers, and that's because no functional reasons can explain why the proposed pool club looks the way it does. It's entirely a matter of preference. Clearly, the pool club's architects have contempt for the plans designed, for your redevelopment plans design standards and what they stand for. And they've therefore designed the building that violates every design standard in the plan.
Before you go forward, do you know whether or not the standards that the ordinance contains for the grant of a waiver have been satisfied by the applicant in the testimony provided?
I don't believe so. Now, the privacy, the precious privacy for the pool club's patrons could easily be accomplished in other ways. Privacy does not justify such an aggressive disrespect for the waterfront streetscape. I also mentioned several objectives from your 2017 Master Plan Reexamination Report, which were, by the way, referred to in your planner's review memo. Urban Design Objective 5.3.1.3 reads, ensure infill development complements the context and qualities of adjacent neighborhoods with an appropriate scale, massing, and character. Urban Design Objective 5.3.1.5 reads, ensure first floor uses in retail and in entertainment districts have an inviting and interesting appearance and are composed of active uses. And then finally, Urban Design Objective 5.3.1.6 reads, encourage redevelopment in appropriate locations in a manner that is compatible with the organic or historic development patterns of the city. I would submit that what's being proposed violates all of these principles, which are your principles. This is a master plan reexamination report. It's your very document. So these are principles that are that have been endorsed by this board. So if approved as proposed, I believe that this pool club will create a very bad precedent for the Asbury waterfront from a design point of view. In fact, I would argue that what's being proposed may well have a blighting effect on its surroundings, which is precisely what the designation of the area as an area in need of redevelopment sought to prevent or seeks to avoid and in the first place. And then finally, Section 8, page 16, there's some thoughts on social justice, and social justice is not clearly or not directly a zoning issue, but it certainly is very much a planning issue. There's every indication, even though the applicant has consistently refused to provide details regarding the proposed pool club's membership, but there's every indication that the target market for this is the elite, the 0.1% of the population that can afford hefty club membership fees and that values the opportunity to socialize with equally wealthy people in exclusive places that are off limits to the general public. It seems to me problematic and sensitive, maybe even obscene, to propose a private pool club in a beach town where a third of the population lives below the federally defined poverty line, and where, as far as I can tell, there are no opportunities for disadvantaged families and disadvantaged kids to even learn how to swim. Again, your master plan reexamination report, planning goal 5.1.2.13 reads, create varied and robust open space and recreation opportunities accessible to all neighborhoods with particular emphasis on youth and seniors. Doesn't say anything about creating private membership clubs that are only available to the super wealthy. As such, I think that the pool club building not only violates the redevelopment plan, the CAFR permit, etc., but it also violates the principles in your expressed in your reexamination report, which is, as far as I know, the most recent planning document adopted by this board.
Mr. Rodriguez, are all the opinions that you offered this evening within a reasonable degree of planning certainty?
Yes.
Well, I'm sure that others have questions for you, but at this time I don't. I would just ask that 06, I'm going to give it to the board secretary so that we can have this part of the record. Okay, thank you very much.
I have
Any questions? Oh,
I have a number of
Please.
questions. Actually, if you don't mind, I'll stay here.
I'm sorry. Did I? That's okay, please.
Okay.
Stay where you are. Actually, we have a little buffer here.
Right, I'm just going to re-engage the screen here. It's been idle for a while. While I do that, Mr. Rodriguez, did you review the waterfront redevelopment plan dated March 15th, 2002?
I believe that's the one that I reviewed.
Okay, I'm going to put it up on the screen here, and Mr. Serpico, you could tell me if you want me to mark the redevelopment plan as an exhibit, or we could just take it on reference.
It's a public document.
We can take judicial notice of it, it's a public document.
Perfect. Okay, well, I'm
Yes,
actually...
That's the one that that looks familiar.
Perfect. So I've put it up on the screen. This is actually directly off the City of Asbury Park's website that I'm accessing it. And it's the waterfront redevelopment plan dated March 15th, 2002. As I ask questions about it, I may refer to certain sections, and it's easier to have it up there.
That's fine.
Right.
Does this include any subsequent amendments?
This does not. And the questions I'm asking are just particular to this version of the document.
Make sure that if none of the subsequent amendments have amended anything that you referenced.
I'm going to be asking Mr. Rodriguez some questions about the sections he relied on.
Just make sure we're on the right sheet of music.
Correct.
Well, it looks like it's been amended a number of times, and the amendments are listed right there on the cover.
Did you review any of the amendments in generating your planning report?
Let's see. I don't have the cover. I only printed certain sections of the plan, so I don't have the cover. But I suspect that the version that I reviewed includes all the amendments up until the one that was just recently adopted.
I have a
like-
problem using a document that is not the most current document.
Well,
for
my question
review
is,
purposes.
what did Mr. Rodriguez review in generating his report?
Well, I don't have the cover of the plan.
Well, how about
I mean,
then?
it's the same cover, obviously. The only question is whether it would contain all of those amendments that are listed there on the cover. And I'm under the impression, and this is a question that I obviously can clarify for you at a later date, because again, I have the plan electronically, but I didn't print out the entire document. But I know there was some amendment that took place earlier this year, yes?
Correct.
And I'm under the impression that so that would not have been, and we were working on this when that took place, so that would not be incorporated in the version of the plan that I reviewed. But the various other amendments listed there on the cover, I'm guessing
Where did you obtain your electronic copy of the redevelopment plan?
I think it was sent to me by Mr. Lieberman's office.
And where did Mr. Lieberman, if you don't mind, obtain that copy? Was it from the city's website?
I can't answer that question right now. My problem is that if you're gonna rely on a document, it should be the current document, that's all. I don't know-
My
I don't
problem
know
is,
what to say.
if I'm going to ask questions about the sections of the redevelopment plan you've cited in your report, I need to know what redevelopment plan you reviewed.
Well, have you compared the sections that I cited with that?
Yes.
And you found discrepancies?
No.
Then that answers your question.
So may we?
think it does.
So may we proceed with using this version from the City of Asbury Park's website?
Let's proceed.
Thank
by
you.
all means.
Okay.
I'm gonna just pull back a little bit here, so I'm not in the way of you, two of you having your discourse.
That's fine.
Excellent. All right, so I'm looking at page 6 of your report, where you talk about the illustrative plan on page 22 of the redevelopment plan. So just for context, I'm going to bring us to page 22. All right. Does this appear to be the illustrative plan that you reviewed?
Right, so let's, to be absolutely 100%
Sure.
certain, let's look at page 22 of my version, which happens to be the first page that I printed, and it's the same plan.
Okay. And you indicated that there is a box located on the location of the proposed, what I'll call a beach club. I understand you're calling it a pool club, but for questioning, I'll call it a beach club. Is this the plan that shows the box?
That's the plan that shows the box.
Do you interpret this plan to be the city council's intended location for the beach club?
The plan that particular plan has no legend. It doesn't say what that means. Now, we can infer from the rest of the map, because it shows existing buildings, and there's a similar graphic treatment for those rectangles along the waterfront. We can infer that those are structures of some sort, but we can't really know what type of structures they are, and we certainly don't know what would go in, what the intention was to go in them, because there's no legend.
Okay, is it your testimony then that the redevelopment plan does not specify that a beach club is to be built between 6th and 7th Avenues and then between the Ocean Avenue and the boardwalk?
Well, the beach, not in this graphic,
Okay. Is there any other place where it's indicated where the beach club should be constructed?
in the narrative.
Okay. And what section was that?
You should know that better than I do. It's in my report somewhere. Let's see. So section 3.2 of the redevelopment plan, which is a section that deals with open space, recreation, and community facilities. At page 23, refers to both beach clubs and pool clubs. And it states, a new private beach club will be developed on the boardwalk between 6th and 7th Avenue in a manner that will not limit pedestrian mobility along the boardwalk.
Okay. On the illustrative plan, is this area between 6th and 7th Avenue along the boardwalk, where this gray box is on the illustrative plan?
Yes.
Is it your testimony that this language is insufficient to determine that that gray box was intended to be the beach club?
This language is in the open space, recreation, and community facilities section of the redevelopment plan. It's not in the zoning section.
Okay. So I'll turn your attention then
This is
to...
not regulatory. This is descriptive.
And is the descriptive language not evidence of any intent as to where the city council intended the beach club to be developed?
Not according to me.
Okay.
The zoning is where it matters. That's the zoning section. That's where the rubber hits the road.
All right. I'm going to turn to page 17 of the redevelopment plan. All right. So on page 17 of the redevelopment plan, did you review this page as well?
I reviewed the whole thing.
Okay.
I just didn't print the whole thing out.
All right.
I have a very weak, printer.
Do you see the line that says a private beach club will be constructed along the boardwalk opposite block 207 without restricting public access to the beach or boardwalk?
I see that. I see that, the thing that's highlighted in blue.
Correct. And
Yeah.
does that give you any indication of where the city council intended the beach club to be constructed?
Well, tell me, what section are you in? What section of the redevelopment plan are you in?
We can scroll up and look. Design principles.
Okay, not zoning.
So is it your indication that nothing in the design principle section of the redevelopment plan should be taken into account by the planning board?
Oh, I
Objection,
think,
I misstated his
I
testimony.
think
Sorry,
the
miss.
design principles expressed in the design section should be taken very seriously, but I don't think that the location of any of uses which don't really fit in a discussion of design principles, no, that should not be taken seriously. Look, this redevelopment plan has some quirks. There's no question about it. It got a little sloppy.
Do you know where Block 207 is located? Or what was then known as Block 207 is located?
There's a map somewhere in the plan. Actually, it looks to me like I have it. I just can't read it because
Is this the map here on page 74?
I can't see anymore. Yes, page 74.
Okay. And is Block 207 the block that is now known as the North Beach condo?
Between 6th and 7th Avenue.
Correct.
That's block 207, yes.
So the block located across from Block 207, is that the location of the proposed beach club under this application?
It is.
Is.
Marked as 227.
So would you agree that the design principles section of the redevelopment plan shows that the beach club was intended by the city council to be constructed in the location where it is proposed in this application?
I would agree that something is proposed for there. In some maps, it's marked as a pavilion, so some kind of a pavilion, which would indicate an open structure. But the design principles section of the plan is not the appropriate place to discuss uses. The appropriate place to discuss uses is in the zoning section.
Okay, and so you give no weight to the statement in the redevelopment plan that says a private beach club will be constructed along the boardwalk opposite Block 207 without restricting public access to the beach or boardwalk?
There are many references to various clubs in this redevelopment plan, but the one absence that really is striking is where it matters, in the section where it really matters, and that's in the zoning section.
Okay, we'll turn to the zoning section next then. You have indicated in your report that there is a difference between a beach club and a pool club, in your opinion. Can you summarize for me what the key difference is between those two uses, in your opinion?
Sure, a pool club can be located anywhere. It's not dependent on a proximity to a beach. So you can have a pool club in the middle of the fields. You could have a pool club surrounded by woods. You could have a pool club wherever you put the pool.
What makes a beach club in your opinion then?
The beach.
What part of the beach?
Access to the beach.
And what do you mean by access to the beach?
It means that I, as member, whether it's public or private or something in between, as a member or a guest of that club, can walk onto the beach and use the beach and go into the water.
Is it your testimony then that in order for something to be defined as a beach club, there has to be direct access onto the public beach?
Well, no, it could be access to a private beach.
Or
The question of the ownership of the beach is immaterial. But yes, the answer is yes, you have to have access to the beach and to the ocean. Unfettered access.
Unfettered access to the beach from the club? Yes?
Correct.
Are there any properties here in Asbury Park between the boardwalk and the ocean that are considered private property?
I don't know.
On the illustrative plan here, is this box between Ocean Avenue and the boardwalk?
I'm sorry. Can you
Right here.
The area that you're pointing with a cursor?
Correct, which is the subject property of this application.
Right. That rectangle, that sort of dark gray rectangle there.
Is there any ability to go directly from this privately owned property to the beach without crossing over the boardwalk?
Not without crossing over the boardwalk.
So by crossing over the boardwalk, are you saying that restricts unfettered access to the beach?
No, I think if the building that's the subject of this application had an exit on the other side, instead of having just one entrance facing opposite the beach, then that would be an indication that there would be some synergy, that there could be some synergy between the club and the beach. But the fact of the matter is, there is no way of getting there other than going around, just like anybody else. And so deliberately, the choice was made to turn this building's back and to turn the attention of all the people who would patronize this building, turn their backs to the beach. That was a deliberate design decision.
If there was a door on the side of the building that provided access to the pedestrian sidewalk that led to the boardwalk, would that satisfy your standard for a beach club?
No.
If there were a door,
It would facilitate anyone who's patronizing the club who wanted to go to the beach getting there without having to go all the way around, but it would still not satisfy the requirement for a beach club, for obvious reasons.
what are the obvious reasons?
Because you have no rights to go on the beach as a member of that club.
So you're saying in order to have a beach club in Asbury Park, it has to come with a right to use the beach that's separate and apart from the public?
If it's a beach club, then you have to have access to the beach.
Access.
That comes as part of the membership.
So in your definition of a beach club, in order to be a beach club, you have to be given special rights to access the beach that are different than the public's. Is that correct?
It's not my definition. No, it's not different than the public because it can be a public beach club, and it's not my definition. It's the definition that's used by when people discuss beach clubs. Read the definitions that I included from Seabright and Long Branch and I don't know where else.
We'll get to
There's
those.
there's always the expectation that the beach is part of the package. If the beach is not part of the package, then it's not a beach club.
So the beach has to be, the public beach has to be able to be used exclusively by the beach club in order to be a beach club?
No.
Okay, then
That's
please.
not what I said.
Then please
The
summarize.
beach doesn't even have to be public. In Seabright, the beach is private.
So if it were a private beach, that would satisfy it being a beach club. Is that correct?
No.
No, then please summarize where I'm missing.
No, the ownership thing is a complete red herring. It doesn't really matter. It's the functional connection between the club, the members of the users of the club, and the beach. And there may be a swimming pool in between. There may be, and frequently there are. And I actually included a photograph of a club that I happened to go to. It was a big mistake, but nevertheless, not at the expense of my clients, mind you, but for other reasons. And it's a very clear layout. You have the club, you have the pool. The pool is not enclosed. You have the beach, and it's all one continuous thing. And there are chairs, and the people who work in the facilities in the club will bring you your, BLT or whatever it is that you ordered, and you can be in the water, you can be on a deck chair on the beach. It's a seamless terrain.
So if the applicant here revised the application to allow the members to use the beach and set up chairs and cabanas and food service on the beach, in your mind, that would make it a beach club?
It would certainly make it more of a beach club than it is now.
Okay. So I'd like to turn to how Asbury Park actually defines beach club as a conditional use. Do you remember what the conditional use standard is for a beach club?
In the redevelopment plan?
In the redevelopment plan.
Yes, there's only one condition, and that is that it doesn't block the pedestrian access on the boardwalk.
Can I just take 1 moment? We have 10 minutes left to use it wisely.
Understood.
You're not gonna make me come back here again, are you?
Okay,
We
so
have reserved the right to
yeah.
call you back, yes.
So turning
We
to-
have reserved the right.
Turning to beach and fishing clubs, can you read what the standard is, the one conditional use standard? It's on page 69 of the waterfront redevelopment plan.
Shall not restrict public access to the boardwalk or public beach.
So if the applicant were to set up tables and chairs and food service on the public beach, would that satisfy the conditional use standard for a beach club?
You mean if the applicant were to propose something that's not this application?
If we were to
something
add,
completely different?
if we were to add tables and chairs and I think you mentioned cabanas and food service to the beach, which is what you've described as a traditional beach club, would that satisfy the conditional use criteria in the waterfront redevelopment plan?
And if you were to make the connection between the pool and the structure around the pool transparent and you know, completely transparent so that it's one continuous facility and you could walk back and forth, then it would qualify, much better qualify as a beach club than it does now.
And having those facilities on the public beach, you don't think would be restricting public access to the public beach?
Well, there's a compromise to be had, obviously. I mean, when those decisions are made to associate a club with public property, it's a decision that's made.
Do you view this conditional use standard as allowing any applicant to construct on the public beach?
No.
Under your definition of a beach club, could any applicant therefore put out structures or chairs or cabanas on the public beach for a beach club in Asbury Park?
Wait, one at a time. Structures, chairs, you did all three.
Any of those things?
Okay.
I think that chairs and you know, umbrellas and those kinds of things that are removable are typically part of that situation. Would you be able to go further? That's entirely up to the governing body here.
All right, moving on from this line of questioning then. When you looked at the definition of beach club, you looked at a dictionary, is that correct?
Well, I started by looking at the definition in that the leisure industry, right?
When that was a dictionary, correct?
It's an online dictionary, yes.
And you looked at ordinances from 3 different municipalities in Monmouth County, is that correct?
Yes, that's correct. I actually looked at more, but these are the 3 that made it into the report.
And the 3 that are in your report, are any of those 3 Asbury Park?
No, because Asbury Park doesn't have a definition.
Did you look at any document, well, first of all, who adopted the redevelopment plan in Asbury Park?
Well, the governing body, like every other redevelopment plan in New Jersey.
Did you look at any other documents concerning the redevelopment area that were adopted by the governing body of Asbury Park when determining what a definition of beach club might be?
I'm sorry, what other documents?
When you were trying to determine what a definition of beach club might be, did you look at any other documents concerning the waterfront redevelopment area that were adopted by the governing body here in Asbury Park?
You mean like the preliminary investigation?
I'm asking any other documents.
What other documents are there?
I take that's a no.
That's a no.
Okay. Did you look at the redevelopment agreement for between the master redeveloper?
I did not.
Did you look at any subsequent developer agreements involving the redeveloper, any subsequent developers, and the city of Asbury Park?
No.
Did you look at the resolution that was adopted by the city of Asbury Park in referring this application to the planning board, in which it found the application consistent with the waterfront redevelopment plan?
I looked at a report from the TRC, which I gather is not the same thing.
No, sir.
So, no, I don't think I did look at that.
Okay.
All right, would this be an appropriate place?
It could be.
'Cause we
I honestly
are-
think I only have about 5 minutes left, and I
Okay.
know we're pushing it, but it would be great
That's-
to try and finish this tonight, so I will try to move it along.
Right, but we would be just finishing these questions, but I'm sure many of us have other questions.
Okay.
So it's just a matter of, do you want to ask one or two more questions, or do we stop here and, because we're going to continue this.
Okay.
So,
If there's
either
going to
way.
be more questions than just mine, then
Oh,
I
there
don't.
will be.
Okay,
Yeah.
then I don't mind stopping here,
Okay.
as long as I can come back and continue my line
You
of
can-
questioning next
we
time.
pick up where you left off.
Okay. Thank you
Absolutely.
so much.
I guess I'm coming back.
I guess you are. Okay, we're looking to, can I get a motion to carry this application to January 27th without notice?
So moved.
Second.
All in favor?
Aye.
Aye.
January 27th.
Nope.
Attorney for the applicant will continue the consent and the extension of time necessary to finalize this application.
Yes, sir.
Okay, we have one other item for the planning board to review, and that's a resolution by, that Jack has.
Good night, everybody.
Good night.
Good night.
Have a good holiday.
Thank you, you too.
Okay.
Before we go forward, I just want to make, are you recalling my engineer? Because
We
I would-
reserve the right to do so.
But for the next
wha-
meeting.
But what we would do is that we would decide that, give you enough time to know if we were going to do that for that particular meeting. Is that all
Okay,
right?
so for the next meeting, she doesn't have to come. 'cause
At,
you have-
at, and at this moment, no.
Okay, but if something changes.
But if
you'll let
something
me know.
changes,
Okay.
we would certainly let you know.
Okay, very good, thank you.
Okay?
Okay.
All right, Jack, what do
On
you got?
that resolution, the only
Please.
comments,
Hold on, we just need quiet, please. Please take it outside, no offense.
okay, Irina, I have a couple of spelling errors that Mr. Kennedy pointed out, his witnesses, bottom of page 2. Kevin Summons is Sommons, which we can clean up tomorrow, and Luke Rudowski, Rudowsky. Okay, page 3, number 2, agreement with the Asbury Park City Council and master redeveloper or agents thereof. I assume we can just edit that in. That makes sense. Number 4, page 417, the landscape designer is not Mr. Bauer. Okay, I had him in there. It's Mr. Melillo, Melillo. Page 4, number 20, says I'm missing the word pre-construction meeting.
Meeting, the word meeting, yeah.
Not
Okay,
pre-construction.
that's fine. All right. I mean, these are clerical.
Yeah.
Appreciate your help. Thanks so much, Kevin Ken.
Okay,
So with those amendments, I would offer the resolution to be adopted by the board, and Irina can tell you who's eligible by looking at the resolution.
now, why don't you take a look to see who's eligible, because I know I am not.
Well, I move to approve the resolution with the amendments.
Thank you.
Do I have a second?
Let's find out who's eligible.
I second.
Alexis,
Yep, I'm eligible.
who I missed very much while I was
Yes.
away.
Okay, Mayor Dunmore.
Oh, am I eligible?
Yes, I'm
Okay.
just gonna call who's eligible. Mayor Dunmore.
Yes. Was that for you?
Here, Michael Manzella.
Yes.
Jennifer Souter.
Yes.
Alexis Taylor.
Yes.
Oh, and
Passed
that's
and
on here.
adopted.
That's it.
That's it. Okay, all right.
Motion
Mo-
to
Go
adjourn.
ahead.
Second.
All right,
Aye.
thank you.
Aye.
Have a good night.
All right, thank you.